We are now live streaming and we may begin when you're ready.
Thank you. Good afternoon, everybody. My name is Jonathan Patoski. I am a county court judge in Garfield County in Rifle. I have been a trial attorney for 30 years this year. Crazy, because I know I only look like I'm a little older than you, but 30 years this year as a public defender, prosecutor, divorce attorney, and I've been a judge now for going on my 11th year. I have been a mock trial coach for 11 years in 12 years now between Glenwood Springs and Rifle. So I know what you're going through. I am congratulating you on getting this far, and I wish you best of luck in this round. Everybody just take a big deep breath, and it should be pretty good. Is the prosecution ready to proceed?
Yes, Your Honor.
And that is Ms. Gazzelli?
Yes.
Okay, thank you. Is the defense ready to proceed?
After a few preliminary matters, Your Honor.
Okay, Mr. Briggs, give me 1 second and we will come back to you. So I know that the scoring judges have told us that there's no conflicts. Have you all received a copy of the rosters, and are you all ready to proceed? Is everybody good to go? Appreciate your time here today. We know that we're live streaming. Is either team recording this? And if so, have you checked with the other side? Is everybody good with how that works? Is there any issues there that we need to talk about?
We're not recording, Your Honor.
Okay.
Nor are we, Your Honor.
Thank you. As we know, since we're live streaming, we also are in a situation where the Colorado Bar Association may be somehow taking pictures or screenshots, whatever. I'm not sure what they're going to do, but if they are doing that, you understand that by participating in this, you basically have given implied consent that works and that there's no issues. Is there anybody that has any problems with any of that? Thank you. Is there anybody that is here who is connected with teams not competing in this round? Because if you are, I need you to leave. We would love for you to watch the live stream, but you can't stay here. As we used to say back in the day, you don't have to go home, but you can't stay here. Any issues with anybody there? Okay. We already talked about the fact that the scoring panelists don't have any conflicts, so we don't need to worry about that. If there are any disputes arising out of the competition, they must be reported in accordance with the competition rules. That your compliance with time requirements is considered in scoring your individual performances. There's no coach or team member other than a timekeeper that is still associated with this Zoom feature. Is that accurate from everyone? Okay, everybody seems to be good. Ms. Gazzelli, if you would, at this point in time, have your team say hello.
Thank you. Good afternoon, Your Honor. My name is Danny Gazzelli, and I will be conducting the direct examination of Kyle Kuzak and the cross-examination of Blake Van Owen. My co-counsel will now introduce themselves.
Good afternoon, Your Honor. My name is Avery Martin. I'll be doing the direct of Alex Afuentes, cross of Taylor Perkins, and the opening statement.
Thank you.
Good afternoon, Your Honor. My name is Jack Walker, and I will be conducting the direct examination of Detective Jordan Markowitz, the cross-examination of Avery Becker, as well as the closing statement. And I would additionally request that the witness for the prosecution may introduce themselves.
Thank you, Mr. Walker. Please.
Good afternoon or good morning, Your Honor. My name is Sawyer Beardsley, and today I am Alex Afuentes.
Good afternoon, Your Honor. My name is Sutton Damiano, and today I am Kyle Kuzak.
Good afternoon, Your Honor. My name is Max Elder, and I am Detective Jordan Markowitz.
Thank you, Team Israel. How about the defense?
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Peter Briggs, and I will be the third attorney delivering the opening statement, the direct examination of Avery Becker, and the cross-examination of Kyle Kuzak.
Your Honor, opposing counsel, and members of the jury, my name is Zoe Mans Jackson. I will be the first attorney providing the direct examination of Blake Van Owen and the cross-examination of Alex Afuentes.
Your Honor, opposing counsel, members of the jury, My name is Jessica Bustillos. I will be the second attorney. I will be doing the direct examination of Taylor Perkins, the cross-examination of Detective Jordan Markowitz, as well as providing the closing argument. Our witnesses will now introduce themselves.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Olivia Dalfolo Daly. I am Professor Blake Van Owen, your first witness.
Your Honor, opposing counsel, and members of the jury. My name is Eleanor Briggs, and I am Taylor Perkins, your second witness.
Your Honor, opposing counsel, and members of the jury. My name is Jaylee Hepner. I am Avery Becker, your third witness.
Thank you to Team China. Appreciate it. At this point in time, we're going to swear everybody in. So if everybody at this point in time would raise your right hand. Obviously, we don't need to stand, but in an effort to maintain a level of professionalism and to uphold the code of ethical conduct during and after these mock trial proceedings, all members of the gallery, scoring panels, and teams shall stand, well, at this point, raise your right hand for the swearing in of the oath of code of ethical conduct. Team members, raise your right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? If so, say I will.
I will.
I will.
I will.
Thank you. Witnesses, if you'd keep your hands raised. Do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statement, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? If so, say I will.
I
I will.
I will.
You can put your hands down. Gallery members, including teachers and attorney coaches, if anybody is here, family members and friends, please raise your right hands. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round? If so, say I will. And scoring panelists, if you'd raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition? If so, say I will.
I will.
I will.
Thank you. I heard the defense say that they had pretrial issues. Does the prosecution have any pretrial issues that they'd like to discuss at this point in time?
Yes, Your Honor.
Ms. Caselli.
We would ask if Your Honor and members of the jury have copies of the stipulations.
I do. I don't know whether the scoring panelists do. But let's assume that they do, or if not, we'll figure it out.
Okay, we would ask if we could reserve remaining time for a rebuttal in the closing argument.
Granted.
And finally, we would ask that if there are any technical difficulties, that time will be stopped for both teams.
That also is granted.
That is it. Thank you, Your Honor.
Thank you. Does defense have any pretrial issues, Mr. Briggs?
Yes, Your Honor. And had I been permitted to object during preliminary matters, I would have objected on the grounds that Rule 4.6 of the competition outlines that the prosecution attorney performing the opening statement is the one that must deliver the stipulations.
Understood.
Your Honor, further, the defense would like to make a motion in limine pursuant to Rule 5.3.3 of the competition that the court will exclude any comments from Detective Markowitz on the defendant's attorney canceling an interview with the detective, seeing as this is an inappropriate comment on the defendant's right to remain silent.
Do that one more time. What's your motion in limine?
A motion in limine to exclude any evidence of Detective Markowitz commenting on the defendant's attorney canceling an interview with the detective, as this is an inappropriate comment on the defendant's right to remain silent.
Are we allowed to have motions in limine in this tournament? I'm not sure whether we are. I understand what you're doing. I'm just not sure whether it's allowed pursuant to the rules. Do you have a rule that says that motions in limine are allowed?
We do, Your Honor. Rule 5.3.3 outlines that evidentiary motions are permitted, and a motion in limine is evidentiary in its nature.
Does the prosecution have a response to that?
No, Your Honor.
Okay, then I will grant that motion. Anything further?
No, the defense is prepared for trial.
Okay. Then at this point in time, is the prosecution ready for opening statement?
Yes, Your Honor.
You may proceed.
She walked up the front steps.
One second. Sorry. Can we switch it so that we can see Ms. Martin and not everybody else? Is that possible to do, Ms. Ackerlin?
I believe if you go to view, Your Honor, click that and you go to speaker, you can just see me or whoever's speaking.
I wasn't sure whether I was doing that, whether that was controlled by the courtroom monitor. So sorry for interrupting you. How about we start again?
Yes, Your Honor. She walked up the front steps, tried the door, locked. Then through the side gate, up the stairs, again to the back door. She slid the back door open without a second thought. She froze. Standing with a knife in his hand was Mr. Brackman. He heard Avery try the front door. He heard the gate open and the back door open. Avery had no plan. She never did. She did what she knew how to do best, improvise. Without thinking, blinded by anger, she lunged for the knife. Ladies and gentlemen of the jury, Your Honor, today we will prove beyond a reasonable doubt the defendant, Avery Becker, is guilty of 2 crimes. Avery Becker had the means, the opportunity, and most importantly, the motive to seek revenge against Coach Brackman. Improvisation was Avery's specialty. It's what started the fights between her and Coach Brackman. He wanted her to show up. Instead of preparing for mock trial, she decided to wing it. The conflict with Coach Brackman is why she was kicked off the team and ultimately why we are here today. Today, we will present all the evidence that proves beyond a reasonable doubt the defendant, Avery Becker, is guilty of the felony murder of her mock trial coach, Mackenzie Brackman. On March 6, 2020, Avery Becker illegally entered Mr. Brackman's house, where he was waiting with a knife from the knife block. They struggled over the knife, making scuff marks in the floor and knocking into the table, shattering a plate. In the struggle, Avery gained control of the knife and stabbed Mr. Brackman, leaving him to die so she could escape. Our 3 witnesses will provide the evidence to corroborate this story. First, you will hear from Avery Becker's mock trial teammate, Alex Afuentes. Alex will testify about the deep anger, the hatred even, that the defendant had for Coach Brackman after he kicked her off the mock trial team. Alex's testimony will show you that the defendant's clear and unmistakable motive is to seek revenge against Coach Brackman. Next, you will hear from Detective Jordan Markowitz. Detective Markowitz will testify about his expert analysis of the defendant's cell phone records. This expert testimony will prove that the defendant was at Coach Brackman's house at the time of the murder and therefore had the opportunity to commit the murder. Finally, you will hear from certified crime scene reconstructionist investigator Kyle Cusack. Ms. Cusack will testify as an expert about her detailed analysis of the crime scene. Her expert testimony will show the defendant, during a struggle with Coach Brackman, was able to stab him with a knife taken from the knife block and inflict the fatal wound, killing Coach Brackman. Additionally, Ms. Cusack will talk about the evidence depicting a clear struggle between the perpetrator and the victim. This important testimony proves that the defendant had the means to commit murder. Avery Becker is charged with 2 crimes. Count 1 is felony murder in the first degree, and count 2, second-degree burglary of a dwelling. Our witnesses' testimonies will show you that she is guilty of both these counts beyond a reasonable doubt. We ask that you find the defendant, Avery Becker, guilty of both counts and not let her improvise her way out of this once again. Thank you.
Your Honor, good afternoon, Your Honor, opposing counsel, and members of the jury. Avery wasn't there. On the morning of March 6th, Avery Becker awoke to the startling realization that her phone was missing. And so for that entire day, while someone else was killing Coach Brackman, Avery was with Taylor Perkins searching for that phone. Members of the jury, in this trial, the burden of proof lies on the shoulders of the prosecution. They must prove to you, beyond a reasonable doubt, that on or about March 6th, Avery Becker broke into the residence of Mackenzie Brackman with the intent to cause criminal mischief and thereby cause the death of her late coach. However, at the close of the evidence, you will find that this burden has not been met, that the evidence is insufficient. Because as the defense, while we have no legal burden of proof in the courtroom today, we will have shown you the innocence in the courtroom by highlighting a lackluster police investigation riddled with mistakes and assumptions. We will do this through the questioning of 6 witnesses, starting with 3 from the prosecution. The prosecution will present Detective Markowitz, who will insist that cell phone tower data places Avery's phone in Brackman's neighborhood, but will provide no meaningful evidence proving that Avery's phone was at Brackman's house, nor proving that Avery's phone was on her person, that they were in any way at the same location. The prosecution will also present Kyle Kuzak, who, as a crime scene reconstruction investigator, will tell you a story. However, yet again, Kuzak will provide no meaningful evidence linking Avery to that story, to the crime scene. You will see that only through a series of assumptions is Avery accused. The prosecution will also present Alex Afuentes, a former teammate and class member of the defendants who, with a clear bias against Avery Becker, has failed to provide their phone for the official police investigation. And thus, any evidence derived from this phone should be taken with a heavy grain of salt. After these 3 witnesses, you will get the opportunity to hear from 3 witnesses from the defense, starting with Blake Van Owen, an expertly qualified private investigator who will outline that there are many ways in which a digital image can be tampered with, underlining why evidence supposedly taken from Alex Afuentes' phone should be questioned. Van Owen will also highlight the many assumptions made by Kyle Kuzak and the many shortcomings inherent in the official investigation conducted by Detective Markowitz. For example, Van Owen will introduce you to an alternate suspect named Blair Rollins with strong motive. And members of the jury, I implore you to listen carefully during the direct examination of Detective Markowitz for any investigation into this Blair Rollins. As a defense, we will also present Taylor Perkins, who will corroborate Avery's alibi. Not only was Avery searching for her phone, but she was with Taylor Perkins the entire day. This testimony will cement in your minds Avery's innocence before we even get to our 3rd witness, the defendant herself. When Avery Becker takes the stand, she will describe in detail her activities the day of and time of the murder. She will describe how she lost her phone, how she was with Taylor Perkins searching for it, and describe the intimacies and the intricacies of her relationship with her coach, dashing any motive cast by the prosecution. The prosecution today will use the creativity of Kyle Kuzak to cover a lackluster police investigation, using assumptions to fill holes where facts are missing. But don't let this fool you into perceiving a coherent story. The defense witnesses, on the other hand, will present a cohesive, unified truth of the events on March 6th, centered around the simple fact of the corroborated alibi. At the close of the evidence, my co-counsel Jessica will implore you to reach a verdict of not guilty because the burden of proof will not have been met by the prosecution. The evidence tying Avery Becker to this crime scene will be insufficient, and the defense will have made clear the many assumptions and shortcomings of the official police investigation conducted by Detective Markowitz. Avery was not there. She and Taylor were looking everywhere. Thank you.
Thank you, Mr. Briggs. And thanks, Ms. Martin. Sorry, I was muted. I'm still not used to the unmute button. So is the prosecution ready for their first witness?
Yes, Your Honor. The prosecution calls Alex Afuentes to the stand.
Ms. Afuentes, you are still under oath. Ms. Martin, proceed when you're ready.
Thank you, Your Honor. Good afternoon. Could you please state your name and spell your last for the jury?
Hi, my name is Alex Afuentes, Sifuentes.
And where do you currently go to school?
Currently, I'm a senior at Colorado High School, but everyone just calls it CHS.
Do you know the victim in this case?
Yes, I was a member of the CHS mock trial team with Mr. Brackman as my coach. I was a junior at the time of Mr. Brackman's death.
And what did you think about Mr. Brackman?
He was an amazing coach and a talented litigator. He was always finding ways to improve our team and our team's performance.
Do you know the defendant in this case, Avery Becker?
Yes, Avery and I went to the same school and were on the team together, mock trial team, that is.
How would you describe your relationship with Avery Becker?
Avery and I have always been very close. She was actually the one who convinced me to try out to mock trial in the first place. I mean, I really liked her and we were practically best friends when we were on the team together.
How many years were you on the mock trial team with Avery?
I would say we were on the team together for about 3 years.
What qualities or attributes did Avery bring to the team?
Well, she played multiple witness roles over the years. I mean, Avery had this amazing ability to make things up on the witness stand and make you believe that it was completely true.
Based on what you personally observed, how did Avery conduct herself on the mock trial team?
Based on what I saw, Avery was always late to practice and was never prepared. But like I said, she was very talented at making things up on the fly.
Again, based on what you personally observed, how did the other members of the mock trial team feel about Avery?
It looked to me like most of the
Objection,
people—
Your Honor. The witness is being asked to speculate.
Response?
Your Honor, this is in no way speculation, as the witness is just testifying to her own personal experiences on the mock trial team.
May I respond, Your Honor?
You may.
The witness is being asked to testify how the other team members felt about Avery, which is something that is far outside the witness's personal scope of knowledge.
Ms. Martin, anything else?
Your Honor, I stand by my response. The witness is just testifying to what she saw based on her own personal observations.
So let me hear the question one more time.
Yes, Your Honor. 1 second. Again, based on what you personally observed, how did the other members of the mock trial team feel about Avery?
That is speculation. If you couched it in a 701 personal, based on her rational perception under Rule 701, which would be lay witness testimony, but you're asking her as to what they feel or think about, that is speculation. There's no way for her to know what they're thinking. Objection is sustained.
Okay, thank you, Your Honor. So moving on, how did you personally feel about Avery Becker's conduct in mock trial?
I mean, I did not like the way that she talked to our mock trial teammates or to Mr. Brackman.
And what did you observe about Avery and Mr. Brackman's relationship in mock trial?
Well, the relationship was always back and forth. It seemed like Mr. Brackman was always frustrated with Avery and Avery was always frustrated with Mr. Brackman. I mean, he was always telling Avery to do a better job, but Avery always simply refused.
And based on your personal knowledge, how did Avery react to Mr. Brackman telling her to do a better job?
It seemed like Avery hated Mr. Brackman for this, and Avery always played the victim and refused to work hard.
So I'd like to discuss the regional mock trial tournament. Did something significant happen to the team before the tournament?
Yes, right before the tournament, Coach Brackman demoted Avery to the B team.
How did Avery deal with being demoted to B team?
Well, right after being demoted, Avery talked to Taylor Perkins, Avery's second best friend, and somehow convinced Taylor to quit the A team for her.
What happened after Taylor quit the A team after Avery got demoted?
I think Mr. Brackman was then forced to bring Avery back up to the A team.
How did the team react to this?
I mean, the whole team was pretty upset.
What happened with Avery at the regional mock trial tournament?
Avery then won Best Attorney Award and Best Closing Argument Award.
And what happened at the next mock trial practice after the regional tournament?
At the next practice, Mr. Brackman officially kicked her off the team.
And based on your own personal knowledge, Were you aware of any reason that Mr. Brackman gave for kicking Avery off the team?
From what I remember, Mr. Brackman tried to explain to Avery that she should not confuse good showmanship with good lawyering. He told her that what Avery did would probably be considered malpractice in the real world.
Again, based on what you personally observed, did you see Avery respond to this?
Yes, from what I saw, Avery was absolutely infuriated by Mr. Brackman's comments, and Avery stormed out of practice.
After Avery stormed out of practice, did you observe Avery do anything else?
Yes, as Avery was leaving the practice, I saw Avery grab a Sharpie pen on the way out of the room. Then Avery vandalized Mr. Brackman's Porsche by writing "Worst Attorney Award" across the hood.
After Avery vandalized Mr. Brackman's Porsche, what happened to Avery in terms of her connections to the mock trial team?
Like I said, after that, Avery was kicked off the team for good.
And based on what you personally observed, how did Avery take being kicked off the team for good?
Avery then texted me and asked me to convince Coach Brackman to let her back on the team.
I would ask Ms. Afuentes to look at the exhibit book and look at Exhibit 14. Do you recognize Exhibit 14? Ms. Afuentes?
Oh, sorry. Yes, this is a screenshot of my cell phone and text conversation between me and Avery.
Is this an accurate depiction of the screenshot you took at the time?
Yes, it is.
Do you know who took the screenshot of the text conversation between you and Avery?
Yes, I took this screenshot.
And when did you take the screenshot?
I took it right after I met with Detective Markowitz.
Your Honor, at this time, I ask the court to admit Exhibit 14 into evidence.
Any objection, Ms. Mance-Jackson?
Yes, Your Honor. A genuine question is raised to this exhibit's authenticity, so under Rule 1003, it is not admissible.
Response, Ms. Martin?
I'm so sorry, Your Honor. Can I hear the objection again?
Sure.
Under Rule 1003, an exhibit is only admissible as a copy or a screenshot, rather, if a genuine question has not been raised to its authenticity. However, a genuine question is raised and will be raised to the authenticity of these text messages.
May I respond, Your Honor?
You may.
Your Honor, as to authenticity under Rule 901B1, Alex Afuentes is a witness who has direct knowledge of the item because Alex has testified that she is the one who took the screenshot of the text messages.
Anything further?
Yes, Your Honor, I would stand by.
Wait. Anything further, Ms. Martin?
No, Your Honor.
All right, Ms. Mance-Jackson, back to you.
I would once again stand by the Rule 1003 that a duplicate, more specifically, which is not the rule that Ms. Martin is referring to, a duplicate is only admissible if a genuine question has not been raised. However, a genuine question is and will be raised.
I am going to find that it is, in this situation, a fair basis to admit the screenshot. And I'm going to overrule the objection, but you certainly are allowed to cross-examine on it as to whether it's authentic or not.
Thank you, Your Honor. May I move on?
You may.
All right, Ms. Afuentes, can you please explain to the jury what you and Avery are discussing in these texts?
Yes, Avery is asking me to talk to Coach Brackman about having Avery back on the team.
Was there anything during this text conversation that made you concerned?
Well, yes, actually. After I told Avery that I doubted anyone could change Coach Brackman's mind about having her back on the team, Avery became enraged. Avery texted that Coach was going to be really upset when he saw what she was going to do to his house.
And did Avery explain what she meant by that?
Yes, Avery said that she was going to wait until Coach Brackman was at work, and then she was going to break in and trash the place.
You testified earlier that you took the screenshot of these text messages. Why'd you do that?
Well, right after Coach's death, I had to go down and talk to a police detective, and I told the detective about these text messages from Avery, but I'd forgotten my phone at home, so the detective asked me to send him a screenshot.
How do these screenshots show that these texts are from Avery?
At the top of the screenshot, it says Avery Becker as the contact.
I'd like to address one more topic at this time, Ms. Afuentes. Do you know a person by the name of Blair Rollins?
Yes, he's another student at CHS, but I mean, I didn't know him very well. I'm not sure if I ever even had a class with Rollins.
Did you ever steal Avery's phone and give it to Blair?
Absolutely not. That's ridiculous. I hardly knew Blair and certainly would not have stolen Avery's phone to give it to Blair.
Miss Afuentes, would you consider Avery Becker a rival of yours?
Certainly not. Before all this happened, Avery and I were friends, teammates. I mean, we pushed each other to be better. Avery and I liked each other very much, which is why Avery texted me to help get back on the team.
Finally, Miss Fuentes, did you have another conversation with Avery after they had been kicked off the mock trial team besides the text message exchange you just testified about?
Objection, leading the witness.
Response?
Your Honor, would you like me to rephrase the question?
Well, if you are going to rephrase, and I'm going to sustain the objection.
Yes, I'm going to rephrase the question.
Go ahead.
Finally, Ms. Fuentes, did you have any other conversations with Avery?
Yes, I saw Avery at the Fry Shack after Avery got kicked off the team. We had this great talk about how Avery should move forward and forget about the trial team. I specifically remember Avery thanking me for asking Mr. Brackman to let her back on the team.
No further questions, Your Honor. I pass the witness for cross-examination.
Thank you, Ms. Martin. Ms. Mans-Jackson, the witness is yours. Oh, wait. Let's make sure that the scoring panels have a minute to. It's been a while since I've been a presiding judge. I've been a coach for a while, so I forget that they actually need to score you guys. Okay, Ms. Mans-Jackson, hopefully that gives them enough time.
All right. Hello, Mr. Fuentes.
Hello.
In your statement, you say that throughout your time on the team, Mr. Brackman wasn't happy with Avery for her lack of preparation.
Yes, that is correct.
You, however, prepared furiously for mock trial competitions.
Yes.
But you claim in your statement that despite this difference in skill, or this difference in preparation, rather, you and Avery were of similar skill levels.
Yes.
And despite being similarly skilled, you agree with Mr. Brackman's decision to demote Avery to the B team.
I mean, she put no effort into the team.
So that's a yes.
That is a yes.
You even went so far as to ask Mr. Brackman why he put up with Avery.
I mean, it had nothing really against Avery as a person. I mean, it was just what she was doing on the team in general.
That's a yes.
Yes.
And you asked that multiple times.
Yes.
In your statement, you even go so far as to claim that Avery won awards based on looks alone.
I mean, most likely.
I'd like to discuss your relationship with Miss Becker. You and Avery pushed each other often in mock trial.
Yes, we were close.
So much so that you say there was a rumor you and Avery were rivals.
I mean, yes, but that is not true at all.
Let's talk about the text messages that were just brought up in direct examination. You should have a copy. And for purposes of mock trial, maybe we consider this exhibit published by the prosecution by the defense, rather, as the prosecution has not done so.
Yes.
Mr. Fuentes, you talk about two specific conversations with Avery in your statement.
Yes.
Regarding the first instance, you say Avery asked you for help getting back on the team.
Yes, that is correct.
And you said yes.
Of course.
And regarding the second instance, you told Avery that Mr. Brackman said no.
Yes.
But these text messages give no indication of two different timestamps.
Okay.
That's a yes.
Okay, yes.
Let's move a little further down the timeline. You were there on the day that Avery drove in your coach's car.
Yes, I was there. I saw her grab the Sharpie.
And Brackman wouldn't let Avery back on the team after that.
No, he would not.
But personally, you believe Avery should have been hit with criminal charges for that incident.
I mean, again, nothing against Avery. I mean, just any person in general who did that.
That's a yes.
Yes.
But you also claim in your statement that you and Avery were best friends.
Yes, we were.
Moving along, you can confirm that Avery was at the Fry Shack on March 5th.
Yes.
A few weeks ago, someone you believe to be a private investigator came to you,
Mm-hmm.
and you
Is that
refused to.
sorry, is that a yes?
That is a yes.
Thank you.
You refused to speak to her,
Yes, I refuse to speak.
despite having information.
Yes, that is correct.
You found out that you were being accused of stealing Avery's phone,
Which is ridiculous. I would never do that.
and also of giving it to Blair Rollins.
Yes, which is also ridiculous.
But you claim that you would never do that
Again, yes, I would never do that.
because you'd put Mr. Brackman in danger.
I mean, yes, and I would not take their phones or give it to Blair.
Right, so you believe that giving the phone to Blair Rollins could put your coach in danger?
Sure, yes.
That's a yes.
Yes.
No further questions, Your Honor. Thank you, Ms. Afuentes.
Thank you. Redirect?
Yes, Your Honor. May I begin?
Yes, ma'am.
Ms. Afuentes, were you ever jealous of Avery?
No, I was never jealous of Avery.
And finally, did you steal Avery's phone and give it to Blair?
No, I would never steal Avery's phone and give it to Blair. I mean, like I said, I hardly even knew Blair.
No further questions, Your Honor.
Thank you, Ms. Martin. Thank you, Ms. Fuentes. Prosecution's next witness, Mr. Walker.
Yes, Your Honor. The prosecution calls Detective Jordan Markowitz.
Okay, just give the scoring panelists a minute before Detective Markowitz takes the stand, please. And while we wait,
Of course.
Detective Markowitz, you are still under oath. It's going to give him another minute. Want you to make sure you get nice and hyped up, Mr. Walker.
Of course.
All right, when you are ready, sir.
Thank you, Your Honor. Good afternoon. Can you please state your name and occupation for the record?
My name is Jordan Markowitz. I'm a homicide detective for the Denver Police Department.
And how long have you been working for the Denver Police Department?
I've been working there for past 13 years, specifically serving as a detective for the past 7.
And what have been your primary practices over those 13 years?
Over the past 13 years, like I said, I've primarily worked as a homicide detective, overseeing countless cases. I also have specialized training in cell phone technology, and I've downloaded and worked with the contents of literally hundreds of cell phones.
And have you had any education outside of the DPD in those areas of expertise?
Yes, so I have a cell phone technology and forensic data recovery certification from the American Academy of Law Enforcement. I completed a 3-day training course and passed a certification test. Throughout this course, I learned how to acquire and interpret cell tower data.
And how frequently do you use this training on an annual basis?
Oh, I use this training constantly as a detective. It's invaluable to most of the cases I work on. I've worked with hundreds and hundreds of phones.
And finally, Detective Markowitz, have you had any prior experience as an expert witness in other cases?
Yeah, as a detective with extensive knowledge of cell phone technology and years of experience, I have obtained and interpreted cell tower data in over 50 cases.
Your Honor, the people would respectfully request that the court qualify this witness as an expert in the fields of cellular device analysis as well as homicide investigation.
Cellular device analysis and homicide investigation.
Exactly right.
Ms. Bustillos, do you have any objection to Detective Markowitz being admitted as an expert in those 2 fields?
Permission for a brief audio, Your Honor.
Yes, ma'am.
Good afternoon, Detective Markowitz. You're a homicide detective
Yeah, that's correct.
with the Denver Police Department.
Yes, I've worked there for 13 years.
Yeah, and you've worked as a detective for 7 years.
Yes, that is correct. I'm really proud of my service.
You feel qualified as a homicide detective
Yes, that is correct.
because you've done so much training to be one.
Yes, I have years of experience within the force.
You worked in the field for a while,
Yes.
but you also studied for years.
I mean, outside of my police work and work within the force, I have no official training, but I mean, I'm qualified to be a homicide detective and I have years of experience.
You admit you have no official training?
Oh, excuse me, I misspoke. As far as outside, excuse me, I have qualifications to be a police officer and a homicide detective, and that is official training. But I believe you are asking towards some sort of other training, which, yes.
I was not.
Okay, my
Don't
apologies.
spend time in training or less qualified for the job.
Oh, excuse me, sorry. Could you please repeat that?
People who don't spend time in training are less qualified for the job.
Yes, but I have put in many years of work and training to be a homicide detective.
I wasn't asking about you, detective.
Sorry.
In fact, that this applies to any job. No training is less qualified.
Yes. Mhm.
You wouldn't trust someone who only had 2 days worth of training to be a detective.
A detective requires lots of skill, yes.
You still wouldn't trust them if they had 3 days.
Objection, Your Honor, relevance.
Response?
I'm laying foundation, Your Honor, to the qualifications of this witness. If you allow me some further questions, you'll see the relevance.
Okay, overruled.
I'll repeat the question. You still wouldn't trust them to do the job if they had 3 days of training.
I mean, if they only had 3 days and were just jumping on it that same day, yeah, no.
Because to become skilled at a training, because to become skilled at a trade, you need more than a few days of training.
Yes, you need experience, you need time, you need effort, yes.
You are fairly new to cell phone technology.
Oh, no, not at all. I have years of experience. I passed the certification test. I've acquired and interpreted, worked with hundreds of cell phones and over 50 cases.
But you've only had 3 days of training to become certified.
I mean, that was the original certification, but I've had years of experience.
Which you admitted earlier wasn't sufficient.
I said that if they had just been stepping off those 3 days and then were immediately thrust into a case, yes, but that's not the case.
No objection, Your Honor, as long as he stays within the scope of his expertise.
Okay, pursuant to 702, Detective Markowitz will be admitted as an expert in cellular device analysis and homicide investigation. Mr. Walker, you may continue.
Thank you, Your Honor. Detective Markowitz, who was the victim in the case we're discussing?
We found an ID on the victim and were able to confirm it was Mackenzie Brackman.
And had you ever seen or met Brackman prior to the crime?
Yeah, I've even worked with him before. He's a criminal defense attorney.
And will that have any impact on your ability to analyze the evidence?
Oh, not at all. My job hinges on being objective.
Okay, let's delve into the evidence. At what point were you assigned to investigate the case?
Well, on Friday, March 6th, 2020, passing motorists reported someone who had appeared to be passed out on the porch of 444 South Flower Street. This was confirmed to be the deceased Brackman, and a team of officers and I responded approximately 2:20 p.m. that same day.
And can you tell us a little bit about the first things that really kind of stuck out to you when you arrived at the scene?
Well, arriving at the scene, the front door was wide open and the victim was lying face down in a pool of blood. They had a large stab wound in their back and were wearing a t-shirt which read "Keep Calm and Mock On." I guess they ran a mock trial program on the side.
Okay, let's get into the digital portion of the evidence. Can you begin to explain how you use cell phone data to narrow the possible perpetrators?
Yeah, I immediately reached out to the school to obtain the contact information for the students on the mock trial team. The first student I talked to actually clued me into some conflict within the case, within the team, which turned out to be the biggest break in the case thus far.
And who was that student?
Student by the name of Alex Afuentes.
And can you tell us a little bit about how Alex Afuentes helped your analysis?
Yeah, so I contacted Alex pretty soon after the event. They told me that a teammate had texted them about a plan to vandalize Mackenzie Brackman's house.
Detective, I'd like to direct your attention to what has previously been admitted as Exhibit 14. Detective Markowitz, are these the texts which Alex Afuentes brought to your attention?
Yeah, Exhibit 14. These are the screenshots I received from Alex from when I questioned him and Alex's parents. According to the message, the defendant asked Alex to help get them back on the team after being given the boot for vandalizing Mackenzie Brackman's car. The defendant then refuses, Alex refuses, and the defendant then proceeds to break in and threatens to vandalize Mackenzie Brackman's house while they're at work.
And why were those text messages significant in regards to your case?
Well, the information I received from these text messages, as well as the interview with Alex and Alex's parents, pointed me towards Avery as a possible suspect. This is what caused me to look into their cell phone records.
And what impact did that have on you?
In my expert opinion, the messages show a clear motive. And as the attack happened during the middle of a workday, it's probable that Avery broke in, wasn't expecting to see Mackenzie Brackman, and was interrupted by the victim.
Okay, can we get into what you found on Avery's telephone?
Yes. So unfortunately, we don't actually have Avery's phone, as they claim to have lost it. However, we do have her call detail records, or CDRs. They can tell us some very interesting things.
And what do they tell you?
Well, they tell us that Avery's phone received several phone calls from a Taylor Perkins on the day of March 6th. I was able to use this information to place the phone at the scene of the crime around the time of death.
And can you elaborate a little bit on that timing?
Yes. So the first thing we know is that the records show that Becker was at home between 12:45 and 12:50 p.m. Avery can then be placed driving along Rock Creek Parkway, 12:55 p.m. The records indicate that they were at Mackenzie Brackman's house from 1:05 to 1:17 p.m. This can all be seen in Exhibits 15 and 16, which detail the cell towers Avery's phone connected with, as well as the most probable route they drove that day.
Your Honor, may I have permission for my co-counsel to share Exhibits 15 and 16 with opposing counsel, Detective Markowitz, as well as the jury?
Well, not with the jury yet, but with the witness.
Okay, fantastic. Thank you. Great. Detective Markowitz, do you recognize Exhibits 15 and 16?
Yes. So these are the diagrams I put together. They show the location of the cell towers, as well as the positions of the antennas that Avery's phone connected with that day. Exhibit 16 also shows the most probable route from Avery's house to 444 South Flower Street, where the victim was discovered.
And do these diagrams accurately depict the cellular telephone data you gathered?
Yes.
And did you create these exhibits?
Yes.
Your Honor, may I have permission to admit what have been marked as Exhibits 15 and 16 into evidence?
Ms. Bustillos, do you have any objection to Exhibits 15 and/or 16 being admitted?
No objection, Your Honor.
Okay, then hearing no objection, 15 and 16 are both admitted.
Thank you, Your Honor. And may I additionally have permission to publish Exhibits 15 and 16 to the jury?
Yes, sir.
Thank you. Detective Markowitz, can you elaborate on cell tower connections?
So cell phones are constantly reaching out to find cell towers, even when the phone is not in use. Cell phone will typically pair to a tower closest to it. However, this is not always the case. For example, if that closer tower is particularly busy, a cell phone might reach out to one farther away, but less busy.
And does that happen very frequently?
Oh, no, not at all. That's pretty rare.
And how are antennas used to further narrow the possible locations of the telephone?
Yeah, so in order to actually connect with the phone, the cell tower antennas use 3-directional 120-degree antennas. Using the information about which specific antenna a phone connects with, we can precisely determine the location of a cell phone at any time. So although cell phones are constantly reaching out, the cell tower providers only record this information when a call or text is placed or received. Luckily, the defendant received several calls and texts throughout the day of the murder that we could use to pinpoint their location throughout the day.
And how did those cell phone tower records aid the case against Ms. Becker?
Well, they show us that Becker was at Mackenzie Brackman's house around the time of death. Before the murder, the records also indicate that Avery was driving along Rock Creek Parkway, which would be the most probable route between their house and the victims.
Detective Markowitz, I have one final question to ask you. What have been your primary takeaways from analyzing this case?
Well, the clear and obvious takeaway is that the objective data gathered by the CDRs gives the straightforward story that Avery Becker's phone traveled from Avery Becker's house to Mackenzie Brackman's house the day of the murder. She spent a significant amount of time around the property around the time of death. And based on all of this evidence, it is highly likely that the defendant was in possession of their cell phone the day of the murder. All the evidence points to their guilt.
Thank you for your attention today, Detective. I have no further questions, Your Honor, and I pass this witness for cross-examination.
Thank you, Mr. Walker. Ms. Bastillas, ready? Yeah, how about just give us a minute for the scoring judges to do what they need to do, and then we will hear your cross-examination.
Of course, Your Honor. Just let me know when you're ready.
Thank you.
Your Honor, may I request a time check for the rest of the direct examinations for the prosecution?
You may.
On direct, there's 7 minutes and 5 seconds remaining.
Thank you.
Thank you.
Ms. Bastillas, if you are ready, you may proceed.
I'll now discuss March 6, 2020 with you. In March, you were assigned to investigate the death of Mackenzie Brackman.
That is correct, yes.
You responded to the scene at 14:20 hours.
Yes, I responded.
You observed the victim at the front door of his residence.
Yeah, they were lying just inside the front door, face down with a large stab wound in their back. There was pools of blood and a knife just behind the body.
But didn't concern yourself with the body right away.
No.
You looked around the outside of the house.
Yes, I proceeded around the gate into the back door.
And found a Ring doorbell.
Yes, there were various Ring doorbells and cameras surrounding the property.
The doorbell being a part of the house's security system.
Yes, I believe so.
The killer was recorded by the cameras.
Yes, there were various videos recorded throughout the day.
You found lots of mock trial related items at Coach Brackman's house.
Yeah, after investigating, not only did he have the shirt, but on his phone, there were many texts and emails. It kind of seemed like he spent more time on that than his actual lawyering.
But highly doubted it was related to Brackman's murder.
I mean, I highly doubted it, but as a good detective, I follow up on all leads. And so I followed that, and then the evidence led me to this conclusion.
But that's a yes, you highly doubted it.
I mean, upon first seeing it, yes, it was more likely that it was a break-in.
I'll now ask about Mackenzie Brackman. He was a criminal defense lawyer.
Yes. Mm-hmm.
One who you described as being a displeasure to work with.
Yeah, he would kind of attack the work of the police and kind of take cheap shots, and that's why I disliked him. I value objective fact gathering and honest police work, and I try to uphold that in my work, and I feel that he didn't, so it kind of rubbed me the wrong way.
Mackenzie Brackman may have been disliked by some of his clients.
I mean, it's a possibility. He's a defense lawyer.
Clients he defended as their lawyer.
Yes.
Some people who were on trial for murder.
Probably.
Objection, Your Honor.
What is your objection, sir?
Opposing counsel is asking my witness to speculate.
Response.
You may.
Your Honor, this witness has admitted to working with Mackenzie Brackman and even being on certain trials with him if he would know what Mackenzie Brackman would, especially if he conducted an investigation about his history.
Anything further?
It's rationally based, sorry.
Mr. Walker, anything further?
I stand with my objection.
He has been admitted as an expert, therefore I'm going to allow him to testify and give his opinion. The objection is overruled.
Some of his clients were on trial for murder.
Probably.
and some with violent histories.
I mean, I don't know the specifics of any of his clients.
I'll now talk about Alex Afuentes. The first student you interviewed was Alex.
That is correct.
You built the rest of your case based off of what Alex told you.
I mean, I wouldn't say built off of it. It was kind of the jumping off point, but I had much more objective data that I gathered that later became more important to the case.
But you built it based off of what Alex said.
I mean, that was kind of the first big break or the first jumping off point of the case.
So that's a yes?
Yes.
Without looking for other possible leads first.
I mean, upon first arriving at the scene, I had a couple ideas, but that was kind of what solidified me down this track.
Alex told you about the text between her and another student?
Yes.
So you asked Alex to come to headquarters for a full interview?
Yes, I asked Alex, as well as Alex's parents, to come down to complete an interview.
Based on the text between Alex and the other student?
The interview?
Yes, the interview was based off of the text between Alex and the other student?
Oh, yeah, sorry about that.
Texts that were on Alex's phone?
Yes.
Alex knew that you were interviewing her,
I believe so.
yet failed to bring their phone to the interview.
Yes, but I asked them to send screenshots afterwards, and they did.
This is weird considering Alex is a high schooler.
I mean, yeah, you don't often see high schoolers without their phones, but I mean, it's a murder case. It's a police investigation that can cause people to act strangely or get stressed.
But yes, it was weird.
I mean, yes, it was odd.
And this is even more concerning because Alex knew her phone was important.
I guess.
You only got sent screenshots of the exchange.
That is what I requested, yes.
And never saw Alex's phone.
Correct.
Nothing was done to verify the screenshots were confirmed to be authentic.
I mean, that's correct, but all of our other evidence corroborates their story.
But nothing was done.
I saw no reason to.
You have no proof that the images weren't manipulated with.
I mean, I have Alex's interview.
I would now like to discuss the cell phone data recovery you pulled on Avery's phone. There is no way of knowing who was in possession of Avery's cell phone on March 6th.
I mean, we do see her phone traveling from a region around her house.
There's no way of knowing who was in possession, though.
I mean, it's Avery's phone.
There were several calls made to Avery's phone.
Yes, that's correct.
All from Taylor.
That is correct.
The calls were so short that they indicate there was no reply.
Yeah, there was likely no connection made.
And the messages weren't returned either.
No.
If you could please direct your attention to Exhibit 15. It shows the towers that Avery's phone communicated with.
That is correct.
Cell tower 1227-3 covers Avery's house.
That is correct.
It also covers Blair Rollins' house.
That is correct.
And if you could think back to the Ring cameras, the murderer can be seen in the Ring cameras.
That is correct.
The murderer is covered completely from head to toe.
Yes, they have a mask on, gloves, a hoodie.
And it is impossible to recognize the person simply by the video.
I mean, yeah, they're covered up from head to toe.
No further questions, Your Honor.
Thank you. 1 second, Mr. Walker, and then we'll see if you have any redirect. You look like you are chomping at the bit, so I think you do. Sir, go ahead.
I just have one question for you, Detective Markowitz, in the interest of time. Do you have any reason to believe that Alex Afuentes fabricated those text messages with Avery Becker?
Oh, none at all. All of our evidence, as well as their interview with their parents, corroborates his story. There's no reason to believe they fabricated it.
Thank you, Your Honor. No further questions.
Thank you. Any recross?
No recross, Your Honor.
Thank you. Detective Markowitz, you may step down. Ms. Caselli, do you have a witness to call?
Yes, Your Honor. We call Kyle Cusack to the stand.
Okay. Ms. Cusack, you are still under oath. Just give the scoring panelist a minute to finish up with Detective Markowitz. And then the floor is yours, Ms. Caselli.
Thank you, Your Honor.
Okay.
What do you do for a living, Ms. Cusack?
I'm a Colorado Bureau of Investigation certified crime scene reconstruction investigator, also known as a CSR. Not to be confused with a police officer. I am in no way a police officer.
And where are you employed?
I'm a civilian employee of the Denver Police Department.
What does your job entail?
Yeah, so I investigate complex crime scenes, which include, but are not limited to, home invasions, property crimes, and homicides. My job is to look at the facts and evidence and reconstruct a complete and unbiased picture.
What are your qualifications to be a crime scene reconstruction investigator?
I have 19 years of experience. I've spent the last 3 years of my tenure with the city of Denver, along with my CSR certification.
Your Honor, I move to enter Ms. Cusack as an expert witness in crime scene reconstruction and investigation.
Any objection? Mr.
Brief
Briggs?
voir dire, Your Honor.
Yes, sir.
Ms. Cusack, you provide no curriculum vitae to the court.
May you repeat the question, please?
You provide no curriculum vitae to the court.
I do not believe I understand what you are referring to.
You provide no resume to the court.
No, I do not.
And you list no formal education in your testimony.
Not in my testimony, no.
You also claim to use a 7-step method for event analysis. Can you tell the jury who invented that process?
I would have to refer back to my notes, but yes, I could.
There's no need, Your Honor. Despite a slight lack of personal knowledge about her processes, we have no objection to Ms. Cusack being entered as an expert in crime scene reconstruction.
Thank you, Mr. Briggs. Then Ms. Caselli, Ms. Cusack is admitted as an expert in crime scene reconstruction and investigation. You may proceed.
Apologies. Can you tell me about why you're here?
Yes, I'm here to give my expert opinion based on the event that occurred on March 6, 2020.
And what was this event that occurred?
It was an attempted burglary that resulted in the murder of Mr. Mackenzie Brockman.
What did you do to formulate your expert opinion about this event?
Yes, so first, I visited the scene of the homicide and reviewed all the police reports, photographs, and security videos. I formulated my expert opinion based off a strict process and 5 key steps.
What is your process?
I always assume that all the cases presented to me will be going to trial. This way, I can undoubtedly conduct a thorough and complete and comprehensive investigation.
What are these 5 steps?
These 5 steps are recognition and documentation, collection of evidence, evaluation of evidence, hypothesis and testing, and reconstruction, which will also include peer review.
How did these steps help you?
They help me refine, organize, understand all the evidence leading me to a conclusion about what happened, and in this case, a conclusion of what happened on March 6th.
If you could please take a look at your notebook of exhibits. We will start with Exhibit 17. What is this exhibit?
Yes, so it's an exhibit I created during my investigation. I used the notes that I took to compile spreadsheets and a complete timeline of events.
Did you use this exhibit during your investigation?
Yes, I did.
Did you create this document using evidence you collected during your investigation?
Yes.
Did you construct this exhibit close to the time of the murder?
Yes, I did.
Is it the regular practice of your occupation to create documents like this one?
Yes, as said before, I do this with every case that is presented to me, no matter the circumstance.
Your Honor, I move to admit Exhibit 17 into evidence.
Any objection, Mr. Briggs?
Yes, Your Honor. There are countless aspects of this exhibit that are vague or ambiguous.
Did you want to talk about them, or did you just leave it at that?
I can mention specifics if the court would ask me to.
Well, let's see if, first of all, if Ms. Caselli has a response to the vague, and what was your second part of that?
Vague and ambiguous, it's part of the same objection.
Okay. Ms. Caselli, do you have a response?
These notes are a overview of Ms. Kuzak's investigation, including a timeline and different things she discovered during her investigation. So while all of the details might not be in the notes, she knows all the details, and these are a brief overview of them so she can testify to them and prove that she took notes and followed the correct steps to come to her conclusions.
Mr. Briggs, what exactly are you saying is vague about Exhibit 17?
The second page of Exhibit 17 features an evidence tracking spreadsheet of which there are evidences of which there are no actual details recorded. Further, there is more evidence on the first page of Exhibit 17 that there's no actual details about. So this would be confusing.
Ms. Caselli, do you have a response to that?
Yes, Your Honor. In reference to page 1 with no details, the columns clearly state different witnesses, when they were interviewed, what evidence number these interviews contributed to, and then a summary of the information and the evidence. In referral to page 2, it's simply a tracking sheet of the evidence with the department evidence number, the date received, the source of evidence, and the provider reference number in order to ensure that all evidence was kept track of during my witness's investigation.
Objection is overruled. You may proceed. Oh, and Exhibit 17 is admitted.
Thank you, Your Honor. Can you tell us about Exhibit 17?
Yes, so the first page is for witnesses and evidence that pertains to them, how I got this information, and a summary of their stance on the case. And the second page is for my evidence that I took pictures of to show how it was handled. And the third page is my possible timeline of events.
How did these notes help you with the case?
They help keep me organized and ensure that I looked at every piece of evidence to construct the most probable chain of events.
Moving forward, we're going to talk about the evidence found at the crime scene. Let's start with Exhibits 9 and 18. Have you seen these pictures before?
Yes.
Do these pictures accurately represent what you saw at the scene of the crime?
Yes, they do.
Did you use these pictures during your investigation?
Yes.
Your Honor, I move to admit Exhibits 9 and 18 into evidence.
So do you want to, normally you would show it so Mr. Briggs knows where we're at. Mr. Briggs, do you have any objection to Exhibit 9?
I know the exhibits they're referring to, and I have no objection to either.
Okay, then 9 and 18 are admitted.
Permission for my co-counsel to publish it to the jury?
Granted.
Thank you. Can you tell me about what you see?
Yes, so Exhibit 9 shows a broken plate on the floor of the kitchen, and Exhibit 18 shows scuff marks near the back door.
Why are these images important to the case?
These images were vital for determining the chain of events that happened, in my opinion. These pieces of evidence are what I used to determine that there was a struggle. The broken plate illustrated that during the fight between Mr. Brackman and the intruder, they hit the kitchen table and knocked the plate to the ground. These scuff marks also indicated that there was a struggle.
If we could turn our attention to Exhibits 7 and 8. Have you seen these images before?
Yes.
Are these pictures accurate representations of what you've seen previously?
Yes, they are.
Did you use these pictures during your investigation?
Again, yes.
Your Honor, I move to admit Exhibits 7 and 8 into evidence.
Mr. Briggs, any objection to 7 and 8?
No objections, Your Honor.
Okay, then 7 and 8 are admitted without objection.
Permission to publish to the jury?
Yes, ma'am.
My co-counsel will now share these exhibits. Your Honor, permission to stop time while my co-counsel shares.
No, ma'am.
Okay, I'll move on. Can you tell me what you see in these exhibits?
Yes, so Exhibit 7 is a picture of the open knife drawer at the crime scene, and then Exhibit 8 is a picture of the knife block on the counter with the largest knife missing.
How did these pictures help with your case?
This evidence is what showed me that Mr. Brackman had an awareness of his intruder. The open knife drawer shows that Mr. Brackman was aware of the intruder and opened the knife drawer in search of a weapon. When he was not satisfied with what he found in the knife drawer, he reached for the larger knife in the knife block, as shown by there being a missing knife.
What did you determine happened after Mr. Brackman grabbed a knife?
After Mr. Brackman grabbed the knife, he most likely went for the back door. The individual struggled over the knife, indicated by the scuff marks, which led to the kitchen where they hit the table and the plate was knocked to the ground.
And what was the final step that happened in this chain of events?
After the intruder disarmed Mr. Brackman and gained control of the knife, Mr. Brackman and the intruder were in a close proximity with each other in a bear hug-like position. The intruder held the knife with the blade facing towards them and reached over, stabbing Mr. Brackman in the upper back and shoulder area, or the aorta.
So when the assailant raised the knife, what direction was the blade facing?
The blade was facing downwards.
Your Honor, as my co-counsel has now made it back into the Zoom, could I ask for permission for them to share Exhibits 7 and 8?
Yes, ma'am.
Co-counsel will now share Exhibits 7 and 8 with the jury.
So, Ms. Caselli, I didn't know that you were having technical difficulties. I just thought that they were unable to find it. I didn't know that they had left.
Oh no, she got kicked out of the Zoom.
So
Your
I'm
Honor.
going to give you an extra 35 seconds if that works.
Oh, okay. Thank you, Your Honor. And thank
Yes,
you.
Your Honor, sorry for my apologies. My internet is very bad right now, so it's very glitchy and it keeps kicking me out.
No, that's fine. She said that she asked for time, but I didn't know that it was because you got kicked out. I thought you were just having trouble putting it up on the screen. So that's the reason that I denied it originally.
It's
So
okay.
Wasn't trying to be difficult with you, Ms. Caselli. I just didn't realize she was actually gone.
Yeah. Thank you, co-counsel, for sharing those images. Finally, Ms. Cusack, what is your expert opinion about what happened in this case?
In the end, the evidence demonstrated that this was clearly a planned burglary, which resulted in the murder of Mr. Mackenzie Brackman by the intruder. Mr. Brackman was alerted to the intruder's presence at the back door before the intruder entered. Unfortunately, in the ensuing struggle, the intruder took and gained control of the knife and murdered Mr. Brackman in his own home.
Thank you. No further questions, Your Honor. I pass this witness for cross-examination.
Thank you very much. Mr. Briggs.
Your Honor, we do have cross-examination.
Just give them one
Miss-
second. Just give them 1 second
course.
just to make sure that the scoring panelists have time. Okay, Mr. Briggs.
Ms. Cusack, can you spell your last name for me?
Yes, Kuzak.
Understandable. Ms. Cusack, you make no mention of ever interacting with any of the tangible evidence in court today.
What do you mean by tangible evidence?
Well, you interact with photographs and audio and video provided to you by the police.
Yes.
And Your Honor, permission to publish Exhibit 17 via screen share, seeing as the prosecution has failed to do so.
Yes.
Ms. Cusack, this is Exhibit 17.
Yes, that is the exhibit that I created during my review of the trial and investigation.
And so you created all three aspects of this exhibit.
Yes, I did everything on there.
I'd like to first direct the jury's attention to the first page. A piece of evidence was gathered from Avery Becker. Was it not?
Yes, that is correct. Yes.
And you labeled this as evidence number 1140.
Yes, that is what is written in the document.
But you don't record what this exhibit is or what this piece of evidence is.
Well, for me, I didn't need to.
But you did incorporate it into your organizational framework.
Yes, I did.
And it influenced your conclusions.
I mean, every piece of evidence is included in my stance on what happened and my reconstruction of the crime. I do not leave out any evidence whatsoever. So of course it would be included. Yes.
Of course, but this evidence is not available to the jury today.
I do believe that there was a problem with, well, I'm confused with what you are referring to.
I'm sorry, I meant to, evidence, whatever evidence 1140 was, is not available to the jury today.
It is not my job to determine what evidence is available to the jury, but I do use everything that is presented to me.
But you were the one that determined Exhibit 17 was viable to be presented to the jury?
Well, if it was something that was used in my investigation, yes.
Okay. And 1140 was used in your investigation.
I believe so. I would use everything in my investigation. As said before, I included everything.
Of course. And this whole framework helps you formulate your reconstruction.
Yes, I do the same thing for every single case that I look at. Everything will be included, and I will do the same thing to ensure that what I believe happened is complete and completely unbiased as well.
Of course, and as you said, everything is included, even potentially fallible evidence.
Well, I would only use evidence that is important to the case, and that would be every piece of evidence.
Including potentially fallible evidence that you incorporate into this spreadsheet.
I do not believe there is any infallible evidence in this case.
But you do state in your statement that you include potentially fallible evidence in your organization. May
I ask what the infallible evidence you are referring to is?
The specifics does not matter, but it is present in your statement that you do include it.
I don't believe that I will answer the question without knowing what evidence you are referring to, as it wouldn't be correct if I do not know what you are referring to.
Of course, but you don't understand I'm asking you about what's in your statement?
Yes, but I would like to know what infallible evidence you are referring to answer your question correctly.
I'm not referring to any. I'm referring to the fact that in your statement, you explicitly state that you include potentially fallible evidence in your organization.
Yes.
Understandable. On this first page, again, you list 3 suspects.
Yes.
Avery Becker.
Yes, that is what is written.
Blair Rollins.
Yes, again, that is what is written.
And you even indicate Alex Afuentes.
Yes.
Now I'd like to direct the jury's attention to the 3rd page. You created this chronological flowchart.
Yes, I did.
In your first of 5 steps to efficient CSR work.
Mm-hmm.
Before evaluating the evidence.
I do not believe that that information is included in my witness statement. If you would still like me to answer that question, I can.
Oh, but evaluating the evidence is your 3rd step in CSR work. And you created this in the first.
Well, yes, it is created in the first, but that does not mean I don't look at everything before I go through my steps.
Of course, but you created this exhibit before your step of evaluating the evidence.
It is written in that way in the steps, but that does not mean that I didn't look at the evidence.
However, you can see at the top of this this flowchart that you based it off of an interview with Detective Markowitz.
Well, I used everything. Yes, that is what is written, but I also used everything as I look at every piece of possible evidence and my review with my team of the actual crime.
Okay, so that's a yes. You derived this flowchart from an interview with Detective Markowitz.
Yes, that is correct.
You indicate that the intent of the burglary was property damage.
Yes, it was a planned burglary gone wrong.
However, nowhere in your testimony do you establish what evidence led you to this conclusion.
Well, I have 19 years of experience. I can look at a crime scene and what I believe happened. There doesn't have to be exact specific evidence, but I do believe that since there is no motive that directly shows that it was a premeditated murder, that it is a planned burglary gone wrong.
So maybe I might have confused you. You don't say in your statement, in your testimony, what evidence led you to this conclusion?
No, I do not.
You also indicate 2 timelines, 2 timings.
Yes, this 2 possible events could have been synonymous with one another. It would not have affected the case in any way.
Of course, but you were never able to determine which was more accurate.
Well, if it doesn't matter to the investigation, I do not believe that a specific time is important.
Of course. Now I'd like to move on to some of your conclusions. Is that all right?
Yes.
Part of your conclusions were based off of ring videos presented to you by the police.
Yes, I look at every evidence and the ring videos was included in that, yes.
Of course, but in these ring videos, it indicates the perpetrator of the crime.
Yes, that is who is in the ring videos.
But this perpetrator is wearing a mask.
Yes, they are wearing a mask. That is correct.
And a jacket.
Yes, that is correct.
And gloves.
Again, yes, that is correct.
And this individual's fingerprints were never found at the scene?
No, they were not. It, however, was not important for my investigation.
Your Honor, I'm sorry. I have permission to stop screen sharing this exhibit.
Granted.
One moment. Oh, I don't know if I know how, actually. Oh, there it is. I'm sorry. Moving on. The perpetrator's DNA was not found. Oh, I apologize.
I think you are out of time.
I see that. Yeah.
Does the prosecution have any redirect?
Yes, Your Honor. Before I begin my redirect, is there any way I could get a time check?
Yes, ma'am.
You have 50 seconds.
Thank you. Ms. Kuzak, did you visit the crime scene?
Yes, I did.
And what is the evidence number 1140 in your tracking sheet?
I would have to refer back to the evidence.
Okay. What is your first step in your 5-step process?
The first step of my 5-step process is recognition and documentation.
And is it your job to identify the perpetrator?
No, in no way is my job to identify the perpetrator. I just look at the evidence and construct a complete, unbiased picture of what happened at the crime scene.
And finally, did you complete all 5 steps before compiling the summary of your 5 steps in Exhibit 17?
Yes, that is a short summary of what I did, but I do so many things other than that. Those are just the main points.
Thank you. No further questions, Your Honor.
Thank you. Does the prosecution have any other witnesses to present?
No, Your Honor. The prosecution rests their case.
Thank you. So before we switch to the defense case, let's give the scoring panelists a couple of seconds to do what they need to do. Ms. Mans-Jackson, do you have a witness to call?
Yes, Your Honor. The defense calls Professor Blake Van Owen to the stand.
Okay, Professor Van Owen, you are under oath still. You may proceed.
Please state your name and spell your last for the record.
Professor Blake Van Owen, V-A-N-O-W-E-N.
And Professor Van Owen, what do you do for a living?
I previously worked for the Aurora Police Department, and I'm now a private investigator, a professor, and I've consulted on more than 100 cases.
What is your educational history?
I have a master's degree in criminal justice through the Ashford University online program. I've taught a course on police procedures at the Community College of the Rockies, and I've taught a course at CU Denver on police practices and social justice. I've been teaching for around 5 years now.
And are you familiar with courtroom proceedings?
Yes, I've testified as an expert witness regularly before in the areas of police practices, crime scene reconstruction, cell tower analysis, and general police investigation tactics.
And how long have you been in this line of work?
I've been a private investigator and expert witness for more than 10 years. In the average year, I'll handle between 9 and 12 cases that are roughly similar to this one in terms of my time commitments.
During an investigation, how do you form your opinions about a case?
As I say in my expert report on this case, I review the police documents and investigation by the prosecution. All of my opinions are offered to a degree of reasonable scientific certainty based on my training, experience, and expertise.
Your Honor, I move to admit Professor Van Owen as an expert witness in crime scene investigation, cell tower analysis, general police investigation tactics, and evidence techniques, as her experience and education qualifies her to give an expert opinion under Rule 702.
Ms. Caselli, do you have any objection to that request?
Yes, I do, Your Honor. May I have permission to perform a brief voir dire?
Yes, ma'am.
And apologies, could the opposing counsel please share the 4 sections that they are admitting Mr. Van Owen in again?
Ms. Van Owen is going to be admitted as an expert in crime scene investigation, cell tower analysis, general police investigation tactics, and forensic evidence techniques.
Thank you. Apologies. You are going to provide expert testimony about what happened at the scene of this crime, correct?
I will testify to my opinion of what happened, yes.
And crime scene reconstruction, by definition, is determining the sequence of events that occurred at a crime. So essentially, you will be providing testimony about crime scene reconstruction.
Objection, Your Honor, this is not going to the witness's qualifications.
Response to that, Ms. Caselli?
Your Honor, crime scene reconstruction is a part of forensic evidence and crime scene investigation, and this witness is attempting to testify about what happened at a crime scene based on evidence, which is crime scene reconstruction.
May I respond?
You may.
Your Honor, voir dire goes specifically to the witness's qualifications, not what she's going to testify to today, but rather what she will be qualified in order to perform her testimony.
Response, Your Honor.
You may.
I'm simply laying the foundation where I will ask that she be omitted from talking about certain things within her expert qualifications.
So it is technically cross-examination. I'm going to give you a little bit of leeway, but not too much, because again, wanted to get back to why she should or should not be admitted as an expert.
Yes, thank you, Your Honor. You are not certified in crime scene reconstruction, correct?
No, but I've been admitted as an expert witness in crime scene reconstruction over 8 times.
And you have no formal training in crime scene reconstruction?
No, but I did meet Kyle Kuzak at a crime scene reconstruction conference.
Your Honor, based on the witness's responses and the admission that they are not a certified crime scene reconstruction investigator and have no training in that field, I ask that their expert testimony be limited to cell tower analysis, police practices, forensic evidence techniques with crime scene investigation, excluding crime scene reconstruction as an area.
May I respond, Your Honor?
May.
A witness may be qualified by her experience or education, and as Ms. Van Owen has actually testified that she has experience in crime scene reconstruction, this is not excluded from her qualifications whatsoever, and she should still be qualified in that field.
I agree. Pursuant to Rule 702, a witness is qualified as an expert if they have education, training, or experience. The example I always use is the drug detective. It's not like he's gone to school to determine how drugs are packaged, sold, whether there's baggies, whether there's scales. That's something that he learns by being an investigator and doing criminal investigations regarding drugs. In this situation, I think that there's been ample experience laid. Therefore, under 702, Professor Van Owen is admitted in the 4 areas that were requested. You may continue, Ms. Mans-Jackson.
I'm going to start by asking you about this case in general. What is your connection to the case?
I was hired by the Becker family as a private investigator.
Are you familiar with the way that the police conducted this investigation?
Yes.
And was it conducted in a thorough manner?
No, absolutely not. This investigation was rushed.
Do you know any of the prosecution witnesses in this case?
I professionally know Kyle Kuzak, and I've been in more than one case handled by Detective Markowitz.
And you see Kuzak here today?
Yes, Kyle testified earlier with the other prosecution witnesses.
And are you familiar with her conclusions?
Yes, I've reviewed the conclusions thoroughly.
Based on your expert evaluation, do you agree with those conclusions?
No.
Why not?
It's clear to me Detective Markowitz influenced Kuzak's findings. Kuzak's entire report is based on assumptions, such as how the murder happened, where the knife came from, and it also has misleading cell tower evidence.
Are you familiar with the police gathered evidence in this case?
Yes, I've reviewed it thoroughly as well.
All right. You mentioned earlier the knife. Can you tell the jury about the relevance of the knife?
Kuzak saw a knife block, missing a knife and a knife wound, and made the assumption that the two were connected. If she looked more closely, she would have seen that the knife brand and size is inconsistent with the rest of those knives in the block and the knives in the drawer from Exhibit 7. It's just as likely the murderer brought the weapon on scene.
You also mentioned you disagree with Cusack on the issue with how the victim was stabbed. Can you explain those inconsistencies?
For Cusack's theory to work, the intruder would have to be much bigger than the victim, but following video evidence, that's not true. A much more logical explanation would be that the intruder stabbed Brackman in the back while he was seated. This theory also lines up with the autopsy report.
Let's move on to talking about the cell tower evidence. Are you familiar with cell tower records?
Yes.
And what do those records indicate?
To put it in simple terms a layman or Detective Markowitz can understand, cell towers aren't like a GPS. In an urban environment, you can make 5 separate calls while being in the same place, yet each of those calls connect to an entirely different tower.
In your professional opinion, are cell tower records accurate?
No, the only information the police has is that the phone could have been at the house. They don't show that Avery was there. The significant thing about the records is that Taylor was messaging the missing phone and Taylor was placed at the mall and Fry Shack, which supports the defense's alibi. The records don't support the prosecution's case at all, but it does the defense.
Is this the only cell phone evidence that you've reviewed?
No, I've also reviewed text message screenshots from Alex Afuentes' phone.
And what's significant about those screenshots?
They're only that, screenshots. The police have the technology to download contents of smartphones. The police did no such things, and we can't trust that Alex Afuentes didn't tamper with them. I'd take everything with 10 pounds of salt.
In your statement, you mention a Blair Rollins. Who's Blair Rollins?
Blair is Avery's fellow Colorado high school student.
And does she have a connection to this case?
Yes.
What's that connection?
Well, in addition to the fact that she attended the same high school as Avery, Blair's father was represented by the victim, Mackenzie Brockman, in court. In fact, I investigated Blair as an alternate suspect.
And why did you suspect Blair?
Blair was also absent from school the day of the murder. Blair's home is in the same area as the defendants, therefore under the same cell tower, and Blair Rollins holds a much stronger motive.
What do you mean by a much stronger motive?
Blair's father, Jonathan Rollins, was found guilty of murder and sentenced to life in prison. Mackenzie Brockman, the victim, was Mr. Rollins' attorney and lost the case. Surely your father going to jail for murder is a much more powerful motive than being kicked off a mock trial team.
Objection, speculation.
Response?
Mayor, Your Honor, the witness is actually just testifying to her own personal experience as an expert.
Response to that, Ms. Caselli?
My response, apologies, Your Honor. This witness stated that not in her opinion that this was a stronger motive, rather that it was a stronger motive.
Overruled. I think originally I thought she was going to say that what Blair Rollins or Jonathan Rollins was thinking, but then she said in the way she phrased it appears to be that it was in her expert opinion that that's a stronger motive. Therefore, objections overruled.
Ms. Van Owen, have you heard Exhibit 22?
Yes, it was part of my investigation.
Without going into its contents, please identify it.
This is a tape from Jonathan Rollins' court hearing.
Is it an accurate tape?
Yes.
And is it an authentic tape?
Yes.
Your Honor, I move to admit Exhibit 22 into evidence as its authenticity and accuracy have been shown.
Any objection to that?
Yes, Your Honor. I object hearsay under Rule 801.
Response?
It's not offered for the truth of the matter asserted, Your Honor.
What is it being offered for then?
It's offered to show just Jonathan Rollins' statement, but even if it were offered for the truth of the matter asserted, it also falls under the excited utterance exception to the rule under 803(2).
Again, how?
How does it fall under the exception?
Yes.
That will become clear when it's published to the jury and played as a tape.
No. Objection sustained.
Okay, moving on. In your professional opinion, does this investigation establish the prosecution's case?
No, the prosecution's case rests entirely on assumption after assumption, inconsistency after inconsistency. Assumptions and inconsistencies do not make the prosecution's case. Avery has a solid alibi. She and Taylor were looking for the missing phone.
No further questions, Your Honor.
Thank you. Ms. Caselli, just give us 1 minute for the scoring panelists to do what they need to do and then cross-examination. Feel free to go ahead.
Thank you, Your Honor. You were a police officer, right?
I was.
And isn't it true that you were sued for using excessive force?
I was.
And you left the police force after this lawsuit?
Yes, the lawsuit helped me realize that there's a number of police techniques and tactics I disagree with.
Now, you're here to provide your expert opinion about this case, right?
Yes.
For the defense?
Yes.
And even though you were a police officer, you have only ever worked for the defense as an expert witness.
Yes, the prosecution likes to use free law enforcement personnel, and, well, you get what you pay for.
And you make money testifying in different court cases.
I do. I'm paid for my time, but not my opinion.
You make around $100,000 per year?
On the high end of the scale.
And you are making money on this case?
I am.
You've made about $7,000 up to this point.
About.
And after testifying, you will make a couple $1,000s more.
Probably.
Defense attorneys hire you with the expectation that you will be skeptical of the police, right?
I'm skeptical of every investigation I encounter.
But you wouldn't get hired if you agreed with the police, would you?
I'm sorry, I don't understand your question.
If you agreed with the police, defense attorneys would not hire you and you would not be here testifying today.
I give an analysis of of the police's investigation. Once again, I am paid for my time, not my opinion.
So if you came to the same conclusions as the police, you would still be sitting there in that chair today testifying.
I did not come to the same conclusion as the police.
Moving on, let's talk about the evidence. You reviewed all of the evidence and said that there were no signs of a struggle.
That's true.
But there was a broken plate on the floor, correct?
Yes.
And an open knife drawer?
Yes.
There was also a missing knife from the knife block.
Yes.
Taken together, these three things are signs of a struggle, aren't they?
No.
Okay. You believe that Mr. Brackman was unaware of his intruder, correct?
I do.
So let's go through the sequence of events in order for this to be true. Mr. Brackman would have had to not heard the intruder trying the front door to see if it's locked.
Yes.
Not heard the intruder go through the side gate.
Yes, he was inside.
Not heard the intruder come in the back door.
Yes.
He would have also had to have been unaware of the intruder walking from the back door to the chair you theorize Mr. Brackman was sitting in when he was stabbed, correct?
Yes.
Now, I'd like to discuss some of your conclusions. You concluded that Mr. Brackman was stabbed while sitting down.
I do.
And you also concluded that the knife was held with the blade facing outwards.
Yes, if you pay attention to the murder weapon, you see that it's specifically designed so that fingers go on one side of the handle. And if you hold it In that way, as an upward fashion, the blade would be pointing upwards.
Yet, isn't it true that you believe that the most common way to hold a knife is with the blade facing inwards or towards you?
It's possible, but how the knife is constructed influences how people hold it.
That was not my question. My question was if you believe that, my question is that you believe the most common way to hold a knife is with the blade facing towards you.
That's the most common way, but that's not what happened in this case.
You concluded that the intruder was small.
Based on the Ring videos, yes.
Yet the Ring doorbells have no objective dimensions, correct?
No.
There were no measurements comparing the height of Brackman to the intruder in these videos, was there?
No.
You concluded that Brackman did not notice the intruder.
I do.
Again, this was something you assumed. There was no evidence to corroborate this, correct?
Yes.
You concluded that the knife was brought by the intruder, right?
It's possible.
Just because the knife was a different brand?
Yes.
And you reviewed the Ring videos during your investigation, right?
I did.
Your Honor, permission for my co-counsel to share the Ring videos with just the opposing counsel and the witness, not the jury.
All of them or?
Just the first one, just Exhibit 10.
Okay, granted.
My co-counsel will now share these exhibits. If you could watch this exhibit, please. Thank you, co-counsel. That is all I will need. Is there a knife visible in the hand of the intruder?
Not in the hand, but the intruder is wearing multiple layers.
But they're not wearing a backpack?
You can't see that from this video, no.
So your opinion is based on at least 4 conclusions that cannot be independently verified.
No.
Thank you. No further questions.
Thank you, Ms. Caselli.
Your Honor,
Yes,
briefly, I would
Yes,
object to the opposing counsel not publishing these exhibits to the jury, or Exhibit 10 to the jury. And we would ask that it be considered published by the defense.
Granted.
And permission for a brief redirect.
Well, let me ask you a question, because I don't think anybody has got Exhibit 10 into evidence yet, have they? So I'm not going to let it get published if it hasn't been admitted.
All right. Permission for a brief redirect.
Yes, ma'am.
Ms. Van Owen, what do you take into account when analyzing a case?
I take into account all the possibilities, the police reports and investigation, and my own personal experience.
And is that what you did in this case?
Yes, of course. It's what I do for every case.
And what did you find when analyzing this case?
The police's case is based on assumption after assumption. You can't.
Outside the scope of the cross-examination, redirect cannot be outside the scope of the cross-examination.
May I
Response
respond
to that?
Opposing counsel has asked the witness multiple times about the evidence that she analyzed in this case. I am also asking the witness about the evidence that she analyzed in this case and her conclusions that she drew from that.
Overruled.
Would you like me to repeat the question or would you continue?
Repeat the question.
When you analyzed the evidence in this case, what did you find?
That Avery Becker did not commit this crime. You can't tell who did. The police's case is based on assumption after assumption.
Thank you, Ms. Van Owen. No further questions.
Anything further, Ms. Caselli?
No, thank you, Your Honor.
Ms. Bustillos, do you have a witness to call?
Yes, Your Honor. Is the scoring panelists ready?
Well, if you call them, we'll give them time to catch up.
Okay, perfect. The defense calls Taylor Perkins to the stand.
All All right, Ms. Perkins, you are still under oath, and just give us 1 second. Okay, Ms. Pasillos.
Good afternoon, Ms. Perkins. Please state your name, spelling your last for the record.
Taylor Perkins, Perkins.
Why are you here today?
I'm here because in an interview with the police, I said that Avery Becker and I were together all day on March 6th, 2020.
And what is your connection to the people involved in this case?
At the time, I was a senior at Colorado High School with my friend Avery Becker, my best friend, I might add. We were on the mock trial team together, and let me just tell you, we absolutely rocked our virtual 2020 graduation last year.
What is mock trial?
Well, in mock trial, high schools compete against each other in a sort of fake court case. Mr. Brackman was our coach, and our team always did amazing. We always won a lot of awards, and especially Avery made the team amazing.
What kind of a teammate was Avery?
Avery was never super prepared, but she didn't have to be. Avery was always still there for the team and did a great job. She was the best lawyer on the team by far.
How did people on the team get along?
Well, for the most part, everyone got along fine, but I guess there was some tension.
What do you mean?
Well, Avery didn't necessarily get along with everybody on the team, specifically Alex Afuentes and Coach Brackman. Avery was
Objection.
never...
Speculation.
Response?
Your Honor, this is rationally based off of the witness's perception.
Anything further, Ms. Martin?
Your Honor, I stand by my objection. The witness was testifying to how Alex and Avery got along, not testifying to how she felt they got along or how she saw them get along.
Response, Your Honor?
You may.
Taylor Perkins has just testified to her very close relationship with Avery Becker, and this is also based off of what she witnessed, so it's a mix of based off of what she knows about Avery and what she observed.
Response.
Objection overruled.
Oh,
would you like me to re-ask the question, Ms. Perkins?
No, that's okay. As I was saying, Avery didn't always get along with Alex Fuentes or Coach Brackman. Although Avery never seemed too serious about it though, and it was always just pranks anyway.
How did Avery feel about the tension?
Oh, Avery always felt so bad. I mean, I could just tell how remorseful she felt after anything happened.
objection.
One time,
Speculation.
Response to that, Ms. Bastillos?
Again, this is rationally based off the witness's perception. These are things that were shared between Avery and Taylor as best friends and things that Taylor noticed about Avery.
This time it is asking how Avery specifically felt. Therefore, that is speculation. Objection sustained.
Did you notice anything about Avery after these tense situations?
of course, Avery always told me how remorseful she felt, especially after the car incident after regionals. She came to me and told me how much she regretted doing it, and it was obvious to me that she really meant it.
How was it obvious?
Avery would do anything to make up for it. She really would.
I would now like to discuss Thursday, March 5th, 2020. What happened that day?
Well, after Avery had been kicked off the team, she showed up to mock trial practice to try and talk it through with the coach, but was told to leave. Avery then came to my house where we hung out and played games on our phones for a while. We later went to the Fry Shack to get something to eat, but that turned out to be kind of a bad choice.
Why was the Fry Shack a bad choice?
Shortly after we got there, the majority of the mock trial team showed up after practice. Alex was with them, and Alex and Avery don't really get along very well.
So then what happened?
Everybody was telling Avery how unfair it was that coach kicked her off the team, even Alex Afuentes. Avery got kind of upset and stormed off to the bathroom. Her phone was still on the table, which really showed how upset she was.
Let's talk about that next day, March 6th. Do you know where Avery was that day?
Yes, she was with me the whole day. She had lost her phone the day before, so we spent the day looking for it together.
Could you walk the jury through that day, starting with that morning?
Yes, Avery picked me up at my house. She hadn't answered any of my texts that morning, and when I said something about it, we realized that her phone was missing.
What happened next?
We decided to go look for it. We didn't really have to be at school that day, so we went to search for the phone instead. We retraced all of our steps, and I called and texted her phone the entire time, but we had no luck finding it.
So after Avery picked you up, where did you go?
We first went to the mall, and we checked every store that we had been in the day before. We didn't find it, and that's when I remembered Avery leaving her phone on the table at the Fry Shack the day before, so that's where we went next.
Who did you encounter during your search for the phone?
We saw tons of people. We talked to multiple store clerks and staff at the mall, and the afternoon shift staff even helped us look for the phone when we were at the Fry Shack. We were very busy looking in every place that the phone could possibly have been.
How long did you and Avery spend looking for the phone?
We burned all day. We spent most of it at the mall and then went to the Fry Shack where the afternoon shift staff helped us look.
Did anything stand out to you at the Fry Shack?
Well, not at the time, but now reflecting on why I'm back at the stand at the first place, yeah.
What did you see?
The mock trial team showed up there while Avery and I were looking for the phone.
Why did this stand out to you?
Well, because they should have been at practice at that time, but apparently Brackman never showed up, and so they left after 15 minutes. Now, it's really weird to think that Brackman was dying while we were talking about him.
Objection.
What is your objection?
Speculation.
Response?
I'm a little bit confused about what was being speculated, Your Honor.
Your Honor, the witness said it was weird that they were talking about Coach Brackman while he was dying. She does not know the time of his death.
Response, Your Honor?
Yes, ma'am.
Considering that Taylor Perkins has sat through this entire trial where the death of Coach Brackman and the events surrounding it were discussed, I think it's understandable that she would know that he was dying during this time now.
I'm just going to let the jury make the decision as to whether he was actually dying at that point in time or earlier that day. Objection is overruled.
I'd now like to ask you some questions about Blair Rollins. Earlier, Professor Van Owen mentioned a student named Blair Rollins. Do you know her?
Yes, Blair is also a senior at Colorado High School. She had a pretty well-known reputation around school.
What reputation is that?
Well, Blair had kind of a thing with Brackman. Everybody knows that Blair hated Brackman for losing the case that sent her dad to prison. Everybody kind of blamed Coach for that, and since then, it's been a major issue between Blair and Brackman.
What is Blair's friend group?
Well, I'm not entirely sure who Blair hangs out with, but I do know that Alex is pretty close with Blair.
What is Blair's body build like?
It's almost identical to Avery's, actually. They look very similar.
I just have some final wrap-up questions. Based on your knowledge of Avery, is Avery capable of this?
Look, Avery could be rash or have an inflated ego at times, but she definitely was not rational enough to commit this murder. And she definitely couldn't have committed this murder because Avery wasn't there. We were looking everywhere for her.
Would you lie for a friend?
Absolutely not. And it even doesn't really matter what I'm saying because there's proof that I'm telling the truth. There were plenty of people at the mall, and the afternoon shift staff saw us at Fry Shack.
No further questions, Your Honor.
Thank you. Ms. Martin.
Hi, Taylor. My name is Avery, and I'll be asking you a few questions if that's okay.
It is.
Miss Perkins, you're best friends with Avery, correct?
I am.
You wouldn't even be in mock trial without her.
I wouldn't.
But you saw Avery and Brackman butting heads frequently.
Yeah, they would butt heads.
And they fought so much that eventually Brackman demoted her.
I wouldn't say that he demoted her because they fought so much. It was mostly just because of the one thing.
So that's a yes.
Yes, I guess so.
Based on what you saw, was Avery upset about being demoted?
Yes, she was.
You even quit the mock trial A team for Avery.
Yes, I did.
And you would do a lot for Avery, right?
I would, but quitting the mock trial A team wasn't entirely for Avery. I didn't super enjoy mock trial, even if I was pretty good at it. I wasn't super attached to it anyway, so it wasn't a big deal.
I was just asking if you would do a lot for Avery.
I wouldn't say I would do a lot for Avery. I would do some things for her since she's my friend, but
so that's a yes.
No.
All right. Well, you found Coach Brackman and Avery's feud funny, correct?
I did.
But Avery getting demoted from A team doesn't seem funny, right?
That was just Coach Brackman having heated and overreacting to something that she did.
So that's a yes.
Yes.
You didn't care to get involved in their feud, right?
No, I didn't.
But you got involved by quitting the A team for Avery.
I didn't see this as getting involved with their feud. I did this because I didn't care very much and because Avery deserved to be on A team. I wasn't getting involved with the feud between Brackman and Avery. I was just getting involved with myself and with my friend.
So you were getting involved with Avery by quitting the team, correct?
Sure.
And you also got involved by helping her try to get back on the mock trial team, right?
Yes.
No further questions, Your Honor.
Thank you, Ms. Martin. Ms. Basillas, any redirect?
No redirect, Your Honor. I ask that my witness be allowed to step down.
Yes, ma'am. Mr. Briggs, I believe you're up next.
Yes, Your Honor. The defense calls Avery Becker, waiving her right to remain silent, to the stand.
Ms. Becker, you are still under oath. Mr. Briggs, when you are ready.
Of course. Ms. Becker, could you state your name and spell your last for the record?
Avery Becker, Becker.
And can you tell the jury about your interview with the police?
Yes, I believe it was Exhibit 17. Cusack shared it. As it highlights in there, I told the police about my alibi the day of the murder, and I also told the police about how Taylor called my phone several times in order to locate it.
And can you tell the jury a little bit about yourself?
Yes, I was on the Colorado High School mock trial team for 4 years, and I was a senior last year. I absolutely loved mock trial. I proved to be really great at crosses and closings.
Was anyone else in the courtroom today a member of mock trial?
Alex Afuentes, Taylor Perkins was, and Coach Brackman used to be. I'm sorry, it's really hard to believe that he's gone.
And can you please tell the jury a little bit about who Alex is to you?
Alex Afuentes is my former teammate. We aren't really friends and we really didn't get along too well, but nonetheless, Alex was still my teammate and I had to respect her even if we did kind of feud.
And now I'd like to move on to your relationship with Taylor. Can you talk about that friendship?
Taylor is my best friend. She was the initial reason I joined the mock trial team, but she was not the reason I stayed on. I just loved the team so much.
What do you mean by best friend?
Well, Taylor was willing to spend the entire day of March 6th looking for my cell phone.
And finally, can you elaborate on your relationship with your late coach?
Coach Brackman wanted
things done up front. He wanted clear scripts. I like to go with the flow of the courtroom and do a not killer cross. I'm so sorry. I meant a really good cross and then do a great closing. But Coach Brackman that just wasn't his style. So this led to something that wasn't entirely great for me.
What did it lead to?
Well, I got moved from A team to B team.
And what happened after you were put on B team?
I was really upset. I felt like as a senior and one of the best people on the team, I deserved to be on the best of the best. But nonetheless, my best friend Taylor quit for me just because she didn't want to be on the team anymore. And she knew that the team needed me. So I kind of forgot about the whole thing, but not what Taylor did for the team.
And what happened at regionals?
Well, at regionals, I won 2 awards. I won the Best Closing Award and the Best Witness Award. Last year, the case problem was about this will and these people fighting over it, and there's a corgi dog. I guess you could say I was the best in show. I had them feeding out of my paw. I was totally possum. I'm sorry. I am just on a mom-dad joke kick today.
And when you won these awards, how did Brackman feel about them?
Coach Brackman felt like my awards were undeserving, and he made this
Objection, Your Honor. Hearsay according to Rule 801C.
Response?
Your Honor, one moment, Your Honor. There is no statement being testified to in this instance.
What was your question?
How did Brackman feel about these awards?
And she started to say what Mr. Brackman was getting ready to say. That is an out-of-court statement, is it not?
Yes, that is. Well.
How about I just do this? I'll sustain the objection. You move on, or rephrase, whatever you'd like to do.
Of course. Can you describe your immediate interactions with Mr. Brackman around this time?
Yes, Coach Brackman, from what I could tell, he was very upset that I got the awards. We kind of exchanged some really horrible words back and forth, and I just got upset and I left practice.
And what did you do then?
Well, I was holding a marker because I was going to write on the board about what I did during regionals. But when I left, I still had the marker in my hand, and I saw Coach's Porsche, and I wrote Worst Attorney Award on the hood of his Porsche. I've done some dumb things in my life, but that definitely takes the cake.
And how did you feel coming out of this event?
After this, I felt horrible. I tried to go to his office to apologize, but he didn't want to hear it. So I texted him to apologize.
Objection, Your Honor. Again, hearsay is an out-of-court statement and an interaction at his office that cannot be attested to.
Mr. Briggs.
There is actually, the point of this testimony is actually that there was no statement made by Mr. Brackman. Avery Becker is testifying to statements that she made, which would not be hearsay.
Mr. Walker.
I stand with my objection, Your Honor.
Well, I will, if there's no statement made, then I'm going to overrule the objection. But obviously, if she starts to say that there was a statement made, then I will have you feel free to object once again, and we'll see where we're at.
Thank you, Your Honor.
Ms. Becker, could you continue?
Yes, so I went to his office to apologize, but I was not able to get in. And then I texted him to apologize, but there was no response whatsoever. I offered to pay him back for the hood. I offered to paint the car. I offered to get it off myself. I basically stalked him because I felt horrible about what I did, and I let him and my team down. But nonetheless, I wasn't able to get back on the team.
And did you ever hear back from Brackman?
I did not.
Now let's bring the jury to just before the 6th of March. Can you describe your activities on the day before, on the 5th?
Yes, so Taylor and I were hanging out at the fry shack, and then a couple of mockers came in. We kind of hung out with them for a little bit, and then we went off to the mall.
And so what happened on the morning of the 6th?
I woke up and I realized I didn't have my phone and I had no idea where it was.
And what did you do about that?
Well, I went over to Taylor's house because I knew Taylor could help me look for it, and we were off to go search for it.
So where did you start?
Well, we first went to the mall. We went through a couple of stores. I'm sure I looked in a couple of pots, but nonetheless, we were still unable to find my phone.
Where did you go after that?
Well, and we went to the fry shack. We looked in booths and on tables, but it wasn't there either.
How long did you and Taylor spend looking?
Taylor and I spent the entire day looking for it everywhere.
What else did you and Taylor do to try to locate your phone?
Well, Taylor called my phone several times so we could maybe hear it. She also texted it, but there was nothing. It just went directly to voicemail.
Now I'd like to move on to some of the testimony you might have heard earlier in this trial. What was your reaction to Markowitz's testimony about the cell phone tower data?
I know that Markowitz says that my phone pinged near Brackman's house, but it doesn't really matter. I didn't have my phone the day of March 6th. I was with Taylor looking everywhere for my phone. And besides, I have no idea where Brackman even lived.
And you saw screenshots of texts Alex Afuentes claims were sent from you. Did you send these texts?
Absolutely not. I would never have texted Alex for anything, and I never thought about breaking into the coach's home. I would never do that. After the car incident, I could never do anything to hurt him again. Besides, the day of March 6th, I was with Taylor Perkins the entire day.
Ms. Becker, what happened to your phone?
I have no idea.
Of course. Now I'd like to discuss Blair Rollins with you. Did you hear Professor Van Owen's testimony?
Yes, I did.
And are you acquaintances with Blair?
No, I've seen Alex hang out with him a couple of times, but I didn't really know Blair, and we never really talked.
And is Blair in the courtroom today?
No, from what I heard from Van Owen, she mysteriously disappeared.
And did you see the ring video presented earlier during Van Owen's cross-examination?
I did.
Were you in that video?
Absolutely not. First off, I hate that outfit. Second off, I have never been a devil for Halloween. And besides, I was with Taylor the entire day of March 6th looking for my phone. I could never be in that video.
Ms. Becker, did you kill Coach Brackman?
Absolutely not. All I wanted to do was fix our relationship and get back on the team, and killing him would never have achieved that. I feel horrible about what I did to his car, and I could never do anything else after that.
No further questions, Your Honor.
Thank you, Mr. Briggs. Mr. Walker.
Thank you, Your Honor. Hi, Avery. My name is Jack, and I'm going to ask you a few questions today.
Okay.
Avery, I'm just to confirm, you never said anywhere in your witness statement that you would reimburse Mr. Brackman for the hood of his car, correct?
I didn't mean reimburse. I said that I would offer to pay to get the car repainted. Reimburse is not what I meant.
Okay, but I believe you never stated anything about paying him back for the hood of the car in your witness statement.
As I just stated, I didn't mean to say that. I did offer to repay. I did offer to get the car repainted, and I offered to get it off myself.
Okay, I'll move on. So you testified that you were really good at mock trial, correct?
Yes, I
Objection,
want.
relevance.
Mr. Walker.
Your Honor, I'm laying foundation for my line of questioning.
So pursuant to Rule 611, this is proper cross-examination. Laying foundation is part of that. Objection overruled.
Thank you, Your Honor. And Avery, even though you thought that you were the best attorney, Brackman always kind of criticized your work, right?
He did, but he still put me in the larger roles. Last year, I was crossing the mother's doctor from the will, and I was even testifying and giving the direct of the, not testifying, but giving the direct of the mother's nurse. So he always gave me the larger roles and he gave me a closing.
Okay, thank you. And it made you pretty angry that he rewrote your closings, didn't it?
Yeah, it was kind of annoying. How are you supposed to learn and do better if everything you do it gets rewritten?
And you also got frustrated that he would always make you kind of stick to the script, right?
I was frustrated about it, yeah.
Okay, let's move to the regional tournament. You won Best Attorney Award, didn't you?
I did.
And even though you won that award, Coach Brackman told you didn't deserve it, right?
He said that.
And that made you pretty angry, didn't it?
It made me upset, yes.
So angry that you stormed out of practice and wrote Worst Attorney Award on Coach Brackman's Porsche, correct?
I wrote Worst Attorney Award on the hood of his Porsche, and that is the one thing I wish I could take back. I feel horrible about it. It should never have happened.
Okay. And after that, Coach Brackman kicked you off of the team, didn't he?
Unfortunately, he did.
And that made you even angrier, correct?
It made me upset, yes.
Okay, now let's move to March 6th, the day Coach Brackman was killed. You stated that you were with your friend Taylor that day, correct?
Yes, Taylor and I were looking everywhere.
And you were retracing your steps from the day before so that you could find your telephone, right?
Yes, it was an iPhone, and I really wanted to find it.
But based on your testimony, no one but Taylor was with you that day, correct?
Yes, but as Taylor previously testified, there was other people around. You can't just expect them all to be empty ghost town.
Okay, but there's nobody at this trial today who can attest to the fact that you were at the mall with Taylor Perkins besides Taylor Perkins.
No, but that's not my job.
And you and Taylor are, I think you said best friends, correct?
Yes.
And just to clarify, Taylor also joined mock trial in the first place because of you, right?
We joined together and we did it together so we could hang out, but she ultimately quit the team because she didn't really like it.
Okay. So I'm just gonna go and say that she did quit the mock trial team because of you, so that you could rejoin the team, correct?
For me and the team, she knew they needed me, so she stepped down so she could ultimately do things that she actually enjoyed and I could be on a team.
Okay. And she also skipped school because of you, correct?
Yes, but we really didn't need to be at school that day, and besides, she's a good friend and she wanted to help me find my phone.
Okay, Ms. Becker, you said in your witness statement that you're really good at spinning a yard, correct?
I said that when I was talking about my closing. I will never do that here. This is an actual trial. My life is at stake here. I don't want to spend my life in the rest of prison, so I am not going to sit here and lie or spin a yarn.
But there's really no way for us to know that you're not using your persuasive experience in these proceedings, do we?
Objection, this is improper character evidence. Under Rule 404A1.
Response?
Your Honor, under 608A, it allows me to ask questions regarding the truthfulness or untruthfulness of the accused.
Response, Your Honor?
You may.
This lawyer is questioning my witness and implying that her persuasiveness has been shown in the past and is being used today. Under 404(1)A, that's just not permissible. It's a character trait, trying to prove that she acted in accordance with that trait right now.
So under 608A, reputation or opinion evidence, a witness's credibility can be attacked by reputation for truthfulness or untruthfulness, but it is in the form of opinion, testimony, or reputation in the community. Objection is sustained.
Okay, Your Honor, I believe I am out of time on my, oh, that's on direct. Apologies. I have lots more time. Okay. Ms. Becker, can we move to Exhibit 14, please?
Of course.
Which has previously been admitted, Your Honor. Can you look at this exhibit?
Sure.
And can you read the first text starting with "I'm sure"?
Actually, can you screen share it?
Yeah, I can. Give me one moment.
Jack, I can screen share it if you need.
That would be fantastic if you could. Thank you, Mr. Zelli. Would you like me to restate my question
Yes, please.
or more my request? Can you please read the first text starting with "I'm sure"?
Objection, this evidence is cumulative. It's already been testified to.
It's cross-examination. I'm not sure where he's going with it, but he's got the right to cross-examine witnesses. So objection overruled.
I don't know why you would want me to read this because I never sent this text message, but I can read it for you. I'm sure you're aware that I got kicked off the team. I'm pretty desperate to get back on. Is there any way you'd be willing to talk to Coach Brackman about having me back on?
And additionally, can you please read the segment starting with, well, if he's upset?
Well, if he's upset about his car, then he's going to be really upset when he sees what I do to his house.
And finally, can you please read the
Again, I didn't send these text messages.
Okay, regardless of the situation, these are text messages that Alex Afuentes said that you allegedly sent. And so I'm just going to question you. Yes. And can you finally read the final text message?
I'm gonna wait.
Yes, I believe it starts with, I'm going to wait until. Yeah.
I'm going to wait until he's at work, then break in and trash it, which is something I would never do because I was with Taylor Perkins the day that is in question here.
Okay. And in your direct examination, you stated that you couldn't have sent these text messages because you didn't have your phone at that time, correct?
I said that I didn't send these text messages because I wouldn't text Alex for anything. We're not friends.
Okay. But Exhibit 14 doesn't show a time nor a date when these text messages were sent, does it?
Well, as I previously stated, it really doesn't matter when it was texted because I didn't send it. And besides, I would never have texted Alex. So yeah, it doesn't show a time, but
Ms. Becker, if you could just answer the question, please.
No, it doesn't.
So even if you did somehow lose your phone on March 6th when Coach Brackman was killed, you could have still sent those text messages on March 5th when you did have your phone.
That's plausible, but I didn't do it.
Thank you, Your Honor. I have no further questions.
Thank you, sir. Mr. Briggs, do you have any redirect?
I do, Your Honor.
At your leisure, sir.
Ms. Becker, why do you say you wouldn't send these texts to Alex?
Alex wouldn't have helped me get back on the team anyways. Alex and I aren't friends, so I wouldn't have texted Alex to get help getting back on the team. And besides, I would have never done something like this to Coach Brackman.
If you weren't texting Alex, what efforts were you doing to get back on the team?
I was texting other people on the team to see if I could get back on, and I also went to go talk to him in person, and I texted him. I felt it was better to get an apology out from me rather than other people.
No further questions, Your Honor.
Thank you, sir. Anything further, Mr. Walker?
No, Your Honor.
Does the defense have any further witnesses to present?
We do not, Your Honor. The defense rests.
Thank you. Mr. Walker, are you prepared for closing argument?
I am, Your Honor.
Okay, let's just give the scoring panelists a minute and then we will go.
Of course.
Sir.
Thank you, Your Honor. Avery Becker had the means, the opportunity, and the motive to confront Mackenzie Brackman and take his life. Members of the jury, the evidence presented in this case today showed that Avery Becker had to get even. She was angry. So angry that she went to 444 South Flower Street and not only broke in, but killed Coach Brackman. There shouldn't be a doubt in any of your minds that Avery Becker committed these crimes. The prosecution presented overwhelming evidence today to prove that Miss Becker committed burglary and murder. Detective Markowitz, a member of the Denver Police Department for over a decade, testified that Miss Becker was recorded driving directly from her house to the Brackman household at exactly the point of the crime. This is a critical piece of evidence that puts Avery Becker at the scene of the crime. Ladies and gentlemen of the jury, this shows that Miss Becker had the opportunity. Avery Becker's only alibi is her best friend, Taylor Perkins. Taylor previously joined mock trial, quit mock trial, and even skipped school so that she could help Avery. Additionally, thanks to Alex Afuentes, we have text messages from Avery Becker on the day of the murder after she had supposedly lost her phone. Avery specifically said in those messages that they would go to Brackman's house and trash it, asking for Alex's help. Miss Becker then got rid of her phone in hopes of destroying all possible evidence. Alex additionally testified that Avery hated Coach Brackman for kicking him off the team. Members of the jury, this undeniably shows that Miss Becker had the motive. Kyle Cusack's expert testimony helped us understand that Avery Becker was capable of committing this crime due to the knife being originally taken from the Brackman household. Members of the jury, Avery Becker had the means to commit this crime. The defense has tried to pin this crime on Blair Rollins, but what evidence is there against Blair? The answer is none. Blake Van Owen, an individual who has no education in crime scene reconstruction specifically, nor any sort of education that qualifies him to testify about the actions that occurred during this crime, and who additionally makes a living from his reputation to consistently belittle the police department, stated that he thought Avery was incapable of committing this crime due to speculative factors, and that Rollins's motive was that she had previously been shown with an angry disposition regarding the results of her father's case. Ladies and gentlemen of the jury, there is no evidence whatsoever that supports Blake Van Owen's theory. The defense has tried to strip the credibility of our case numerous times by saying that there was a rush to build a case, yet shown by Kyle Cusack, who spent countless hours reconstructing the scene for us to further analyze, as well as Detective Markowitz, who took the time to process all of the CDRs from Avery Becker's telephone on the day of the murder. It's impossible to make such an accusation. The prosecution must show beyond a reasonable doubt that Avery Becker is guilty of the crimes of first-degree murder and second-degree burglary. We have met the burden of proof. Ms. Becker said that she would get back at Brackman if it was the last thing she did. And so we request that the jury find Avery Becker guilty on both counts and not let Ms. Becker improvise her way out of another dire situation. Thank you.
Thank you, Mr. Walker. Ms. Bustillos.
Your Honor, had I been permitted to object during the closing argument, I would have objected to arguing facts not in evidence, as the prosecution mentioned that Avery got rid of her phone, but there was nothing to back that statement.
Understood. It's an argument, and that is a suitable inference for Mr. Walker to make from the evidence that was presented during the trial. So had you been able to object, I would have overruled your objection. But if you are ready for closing, you may proceed.
Avery wasn't there. She and Taylor were looking everywhere. My name is Jessica Bustillos, representing the defendant Avery Becker in this case. Today, we are all here to make sure justice prevails. And the way to do that is to help keep the system working and protect the innocent. On March 6th, Avery noticed her cell phone was missing. While someone else was killing Coach Brackman, Avery was with Taylor looking for the phone. She was nowhere near the Brackman house and did not kill her coach. Avery wasn't there. She and Taylor were looking everywhere. It is important to remember the jury instructions while looking at this case. Jury instruction number 2 reminds us that the burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. The prosecution has failed to do that here today, and they have failed for one simple reason. You cannot find an innocent person guilty of a crime they did not commit. Jury instruction number 2 also says every person charged with a crime is presumed innocent. And jury instruction number 6 reminds the jury that the assumptions made by experts are still just opinions and not facts. You may believe some, all, or none of a witness's statement. The reason these jury instructions exist is because we don't want an innocent person to get convicted. I urge you all to look at the evidence before you and the woman whose life is at stake and make the right decision. Don't let a wrongful conviction happen here today. The prosecution brought forth 3 witnesses. They called to the stand Detective Jordan Markowitz. Detective Markowitz, an expert in cell phone data analysis, admitted that there's no way of knowing who was in possession of Avery's cell phone on March 6, 2020. Nor can Detective Markowitz confirm the authenticity of Exhibit 14, the text messages. Detective Markowitz also told you of the several calls and texts made to Avery's phone by Taylor Perkins. The calls were so short that could only mean that the calls were not answered, and either the calls or the texts were returned. This proves that Taylor was calling Avery's phone in an attempt to locate it, and Avery wasn't in possession of her phone on March 6th. Detective Markowitz also confirmed that Blair Rollins' house is across from Avery's, and Blair would take the exact same route to Brackman's house as stated by Markowitz. You also heard from Kyle Kuzak, a crime scene reconstruction investigator who was unable to confirm for a fact that the murderer was Avery. Kuzak was only able to offer to the court as someone with the same general build as Avery killed Coach Brackman. And considering how many people share the same build, it is impossible to find Avery Becker is guilty. Just think, at Colorado High School alone, there's another person with a near identical build as Avery, that person being Blair Rollins. They also brought forth Alex Afuentes, a senior who was also on the mock trial team with Avery and Taylor. Alex failed to provide her phone for the investigation. Considering the modern era and the many ways images can be manipulated, we are forced to reconsider the accuracy of Exhibit 14, the screenshots. Alex has also admitted to not liking the defendant Avery. This kind of bias can easily be influencing Alex to lie about Avery, and the accuracy of her statement should be taken with a grain of salt. Next, 3 defense witnesses were put to the stand. First, we brought Professor Blake Van Owen, who showed the initial analysis done by Kyle Kuzak and Detective Markowitz was deeply flawed. Professor Van Owen was able to uncover numerous mistakes made by the police. Van Owen showed you the investigation failed to consider other suspects and even manipulated their conclusions to help blame Avery for a crime she didn't commit. Blake not only proved Avery's innocence, but even brought forth a far more likely suspect, Blair Rollins. Next, you heard from Taylor Perkins. Taylor confirmed that Avery couldn't have possibly committed the crime, seeing as they were together the entire day looking for Avery's phone. And Taylor Perkins also brought forth that Blair had a very similar body type. Finally, you heard from Avery herself. Avery, who waived her Fifth Amendment right because she wanted you all to know what really happened. Avery is a kind-hearted young woman with a bright mind. Avery has made mistakes in the past, but murder isn't one of them. Avery also confirmed that she was with Taylor all day on March 6th looking for her lost phone, and also showed her deep remorse for any previous tensions between her and Coach Brackman. We are all here to let justice prevail, and the way to do that here today is to confirm what we all know, and that is the fact that Avery Becker is innocent. Avery wasn't there. She and Taylor were looking everywhere. Thank you.
Thank you, Ms. Pastillas. Mr. Walker,
Thank you, Your Honor. May I begin?
do you know how much time you have left?
I do not, but I'm going to be very brief. I believe I only took a few minutes in my preliminary closing statement.
Mr. Walker has 1 minute and 20 seconds remaining.
Thank you, Mr. Walker.
Fantastic. Thank you so much, Your Honor. The defense would like you to think that there was a jump to conclusions about this case by Detective Markowitz. But Detective Markowitz used his years of experience in this line of work to refine the possible culprits, pile up the evidence against that individual, and follow that lead. He had no reason to believe that Avery's phone was tampered with. The possibility of Avery Becker being the perpetrator presented countless instances of undeniable evidence that have been presented today. Additionally, there was absolutely no evidence presented against Alex Afuentes nor Blair Rollins that was anything beyond speculative. This case was built with a knowledge that by the end, the prosecution would show beyond a reasonable doubt that Avery Becker committed this crime. The prosecution has met this burden. Thank you.
Thank you. All right, so the scoring panelists, if you would finish up, and then when you're done, if you let me know and get your scoring sheets electronically submitted, what I'd like to do is just have you real quick introduce yourselves, tell everybody who you are, give a brief comment on how you think they did, and then we'll move on to the next person. I know that they were telling us earlier that we can't spend too much time while they are finishing up, and I'm not going to make any comments until after they do, but I am going to tell you this. I appreciate everybody's hard work. I think it was very well done. Obviously, you made the state tournament for a reason. I do have comments about the actual people, but I want to wait until everybody is done and they have an opportunity to speak. And if everybody else, if all the participants would turn your video on, so that way, if Mr. Cohn, Mr. Pereira, Ms. Henson, and Mr. Johnson can see who they're talking to, it would probably help them maybe give you some constructive criticisms or comments or whatever they would like to do. And I'm going to switch to gallery view.
All right, I can go ahead and start. Great job, everyone. I think that you all were really fantastic, and I love getting to see you perform. I saw a lot of stuff that I really liked. With the openings, I love the way that you guys laid out a roadmap of you will hear with this witness, then we'll call up this witness, you will hear, the evidence will show. Those are really great phrases that I like.
Mr. Cohn, real quick, can you just tell them who you are, what your background is?
Yes, apologies. My name is Ryan Cohn, and I am a law student who's been on the verge of graduating for a very long time. So I've done a good amount of mock trial, as well as this is my fourth time judging this particular case, which actually brings me to the defense. I really liked one thing that you guys did was you were very cohesive with your theory of the case in putting forward an alternate suspect in Blair Rollins. And I like that a lot. Yeah, I'll pass it on to the other panelists.
Thank you, sir. Mr. Johnson.
Good afternoon, everyone. Thank you, Your Honor. My name is Russell Johnson. I am a senior attorney with the Colorado AG's office. I want to thank you today for a great performance. I've been judging mock trial for the past 6 or 7 years, and this was certainly one of the standouts for me. I thought you all did a great job. I want to particularly mention one thing in particular that's really important whenever you're going to trial and you have a team, and that is teamwork. I think it came across today, but there was one moment that really stood out to me, which was when we were trying to get an exhibit up, and someone piped in and said, I can put that up. And so the attorney who was doing the questioning didn't have to spend time taking away from what they were doing. They could focus on the questioning, and someone else was getting the screen ready and bringing that up for the jury. That's the kind of thing that really helps when you're in the middle of trial. It's the passing of notes. It's the making sure you have the exhibit binder in front of you that you need. And with this being virtual, it's being there to screen share when somebody else can't because they're trying to focus on something else. And I think the fact that you all worked really well as cohesive team came across in the presentations, and I really appreciate that.
Thank you, sir. How about Ms. Henson?
Hi, so I'm Alex Henson. I'm a fellow at the First District in Colorado with Judge Ty in Division 7, which a fellow is basically a law clerk. You don't know, but I thought you guys did really well. I enjoyed watching you. I always learn a ton from watching mock trial. I didn't do it in school or in high school, and so I'm always kind of shocked and really impressed at the skill that you guys have. I'm like, I don't think that I could do that well. So yeah, great job overall. I think something that probably the only thing that I could criticize really is I think showed a little bit sometimes through reading off the script. So, I mean, I know you have a computer right in front of you, so it's very easy and tempting, but I would try your best to stay away from that, or, you know, at least just have bullet points and not have like actual scripts right in front of you. I think that can hurt you a little, make it hard to kind of deviate at all and throw you off when something goes wrong or something that happens that you didn't expect. But overall, really great job. And congratulations to everyone. You did great.
Thank you. Mr. Pereira.
Thank you, Your Honor. I'd like to echo what everyone else is saying. That was a really good job. One thing that impressed me for both teams is you guys are clearly prepared, and it shows because your opening you used the same improvised or the same wasn't even there, and then you brought that up again at the closing. So that means that you guys had a roadmap and a plan from the beginning of where you wanted the case to go. So I thought that was very good. I want to echo what Alex is saying as far as don't read. And another thing that comes with practice too is controlling your witness, especially on cross-examination. Ways to stop them, ways to say, so that was a yes, or things like that to try and get a yes or no question, or yes, no answer to your question would be ways to improve going forward. I think both sides did a very good job of as far as a clear objection and understanding the law behind the objections and why you are objecting. And that was really well done. Another thing that I appreciated as someone who's just watching is transition sentences. So now we're going to talk about this. So now let's talk about this. So I appreciate that. It makes it easier to follow. I think both sides did that very well. So the witnesses, I don't know how to judge witnessing exactly, but it seems like you guys know the fact patterns as well. And I think I skipped over as far as what I am. So I'm going to do it in reverse order. My name's Anthony Pereira. I work with Metro Volunteer Lawyers. I'm an attorney with them. It's the pro bono arm of the Denver Bar Association, helping low-income families with a variety of civil legal needs.
Thank you. Appreciate you guys' time. The only thing I'm going to say, I do think everybody was smooth. Everybody was prepared. Everybody knew their role. I do echo what Anthony said in that a lot of times on cross-examination, you let the witness ramble and waste your time and run on and on and on. And it could have been easily controlled with I'm just going to ask you now, yes or no questions once you saw that was happening, because if you want them to allow them to spend time on redirect, well, a lot of times they didn't have any time on redirect. So it's not a situation where they could have done it because they're wasting your time and you weren't controlling them. But a lot of you guys were just really, really good, very polished. The only other thing that I would suggest that I like to teach my teams, and this may be strategy more than anything else, is the rule numbers. I think you score more points with the judges, and they could probably answer this better than I could. But if you're saying, pursuant to Rule 701, this is lay witness testimony. Pursuant to Rule 801, this is hearsay. And we got some of that, but we didn't get all of that. And there's really no reason for you guys at the state tournament level to not be throwing out those rule numbers. 401, relevance. 701, lay witness, whatever it may be. Because again, I do think that you get that extra little edge. And when we're talking at this level, it's really slivers because you're all good. You all know what you're doing. You wouldn't be here if you didn't. So how are you going to impress Ms. Henson? Well, you start throwing out rule numbers and the other person's not. Maybe that just gives you a little bit of an edge. So I will be happy to stay around for a couple minutes if that's something that you guys want. If you want individual comments, I'd be happy to give those. Other than that, I think I'm supposed to send you on your way and wish you luck with the next round. So I hope everything